May please, Your Lordship. Lordship, calling for requisition of an additional affidavit filed in item number 10.
Okay.
May please, Your Lordship. So back to mention item number 1 of today's daily list, madam. I've taken consent from the learned counsel of the state respondents also. My senior Mr. S. Smith is having some personal difficulty today, my lord. So I'm praying the matter will list after vacation.
Yes, prayed for by the learned counsel for the petitioner. List again after the vacation.
All right. May please, Your Lordship.
I think this will go with item 2 also.
Yes, my lord.
One
Similar order.
Have you informed? Acha, he's there in both
I
cases.
informed, my lord.
All right.
May please, Your Lordship. Lordship, I would like to mention the listing for WBC Lordship. Today, Lordship, unlisted Lordship. This urgent matter, Lordship, is if today is not hard matter, Lordship, it will automatically intersect session.
No, you mentioned before the registry.
It's possible, Lordship, last item, Lordship, today.
What is the urgency? Tell me.
Lordship, we challenge, Lordship, Government of Elementary of Education last time publishing notification, Lordship. We all are DLED qualified candidate, Lordship.
Yes, so?
Almost 159, Lordship.
So?
So Government of Assam, Lordship, asked to produce 10 documents, Lordship. Which are, Lordship, totally, Lordship, unethical, Lordship. So
There's no urgency as such. I think you mentioned before the registry. Okay, take it up before the registry.
Lordship, already, Lordship, verification process is ongoing, Lordship. Already, Lordship, verification process is ongoing, Lordship.
You make it, take it up before the registry. See, we have a bench on Monday also and on 10th also, I think.
If possible,
He'll be listed on that. Take it up before the registry. Yes.
Lordship, I'd like to mention item number 3 and 4, Lordship. Matter may be adjourned for the day, Lordship.
John,
Yes, Lordship.
why?
Lordship, Mr. Pine is unavailable today, Lordship.
As prayed for on behalf of Mr. J. Payang, learned counsel for the petitioner, matter stands
Matter
adjourned.
will be listed after vacation, Lordship.
Will be listed again after the vacation. Yes.
Obliged, Lordship.
Daily list, item 5.
None appears for the petitioner when the matter is called. Stop. Same was the case when the matter was listed on 13/12/2024. Stop. Matter stands dismissed for non-prosecution.
Item 6.
May please, Your Lordship. May please, Your Lordship. Your Lordship, this matter was heard this matter was heard 3 times, and after hearing, interim order was passed. However, I feel inadvertently notice was not issued. Your Lordship sees the order dated 25/10/2024. That's the third order. First also, 21st/10 also, interim protection was given, which was.
What is the matter about?
Your Lordship, the petitioner hearing is in OBC category. And for admission in the medical session, like 24/25, she had to get a sign from the director of social welfare department, a countersign, a form, which he had refused to sign, though she had a valid caste certificate. The director had doubted the caste certificate without any basis.
Okay.
So the law.
Okay. We'll issue notice then.
Yes, notice needs to be issued.
The department is health, is it? What?
Yes,
No,
health.
what health department is it?
Yes, health is there. Then the state is also there.
Who's appearing?
For the health, last time, Mr. V. Gogoi had appeared. If your Lordship see 25/10, P. Saikya can accept notice on 1, 6, 8, and 9.
You are Mr. Sharma.
Yes.
Heard Mr. R. Sharma, learned counsel for the petitioner. Issue notice of motion, returnable by 3 weeks.
I will. Well, Your Lordship, I am appearing for Social Justice Department, Your Lordship.
Miss
Ardeka.
Ardeka, learned counsel appears for respondent numbers.
May I please, Your Lordship?
Hmm.
Lordship, I have received an instruction, Your Lordship. I have received a speaking order from the SLSC, Your Lordship. Lordship, my instruction is that SLSC is taken the decision that he is not belonging to the CGL community, Your Lordship. Lordship, may I pay the matter is taken after some time I place the instruction, Your Lordship.
You follow the instruction. I'll issue notice. A short date will be given.
Okay.
Appears on notice, excess notice on behalf of respondent number 7. Then who else? Your good name? Ms. Ende, learned counsel appears on behalf of Mr. Ardha, who represents respondent number 2 and 5. Hmm?
We have given an application to registry, but they have asked us to
Sorry?
address the board. We have given an application to the registry regarding withdrawal of the wakalat number, but they have asked us to present this in the board.
Wakalatma on behalf of whom?
Six.
Who's respondent number 6? Director?
Yes.
Then who remains? Please repeat what I've said regarding notice.
Seven.
Yes.
Seven.
Seven.
He represents this, just,
2 and 5, no? So 6 will go, then who remains? Medical education. Government advocate, anyone?
Medical, Mr. B. Gogoi.
B. Gogoi.
I will inform him. B. Gogoi is a standing counsel.
Mr. B. Gogoi, learned standing counsel, Health Department accepts notice on behalf of respondent numbers
3 and 4.
3 and 4.
I am for appointment number 7, Your Lordship.
Yes, that we have recorded already.
Yes, sir.
Then government, Deputy Commissioner Sonitpur, additional DC,
One advocate.
Mr. B. Diori, learned government advocate, accepts notice on behalf of respondent number 8 and 9.
Additional Deputy Commissioner of the email,
8 and 9.
8 and 9.
Then who remains? Oh, no, 1, 8 and 9, I think. One
One,
also. 1, 8 and 9. As such, notice is complete upon the respondents except respondent number 6. Petitioner to serve requisite copies of the writ petition to the learned counsels appearing today. Next para at this stage, Mr. P.P. Gogoi. Your name is then the Vakalanama?
Yes.
P.P. Gogoi, learned counsel submits that. Why do you want to withdraw? You're not the one who's pressing it. Somebody is filing against you. It is not your writ petition. Mr. So-and-so submits that he would like to withdraw the Vakalatnama. Post of as such, respondent, the name of Mr. P.P. Gogoi, learned counsel for respondent number be struck off from the cost list. List the matter again on so-and-so. Give a date, short date,
21/7.
21/7.
Apply.
Respondents to file their affidavit in the meantime.
In the meantime, interim order.
Interim order passed shall continue till the next date of listing.
Obliged.
Obliged, Your Lord.
Item 7.
My lord, this matter relates to compassionate appointment, my lord. Here the petitioner's father died on 11/8/2013, my lord.
Hmm.
And he applied on 2/4/2014.
Hmm.
And his case was not placed before the DLC. Accordingly, he approached this honorable court by filing a writ petition. And the order of the writ petition is at page 27 to 29, my lord. There was a direction to place before the DLC, my lord, page 29. Accordingly, it was placed before the DLC, and the DLC has recommended the petitioner, my lord, at page 41, my lord. DLC dated 15/6/2024.
15/6/24.
Yes, my lord.
Now, DLC of which district?
DLC Karimganj, my lord.
Karimganj.
And it is page 42.
Serial number?
3, my lord. The DLC has decided to recommend the applicant for appointment on compassionate ground, and it reveals from report of DEO that there is no vacancy available for appointment on compassionate ground as per prescribed quota of 5%. in the grade 4 consumers to the qualification of the applicant in the establishment of DO Karimganj, and accordingly it has been decided to recommend the applicant for appointment against the admissible vacancy in grade 4 post of any other administrative department office as per para 15 of the Gov OM number so and so dated 1/6/2015. The DEO has been requested to take up the matter with the other departments.
Hmm.
So, my lord, it is very specific, my lord. Since there was no vacancy available in the department, my lord,
Mr. Deori,
Yes, Your Lordship.
can be disposed?
Uh, uh,
last
Yes.
sentence, also to take follow-up steps for obtaining approval of SLC immediately. Last sentence, my lord.
So based upon this, it can be disposed of. Serial number 4.
Serial number 4.
Yes.
That was forwarded on 3/9/24.
Yes.
So let them take a decision.
Yes.
Okay.
My lord, serial number here, serial number 3, my lord.
No, it's instructions. He has got instructions. Your name is already forwarded
Yes, my lord.
on September 3rd last year. So we'll ask them to finalize it. Hmm.
It may be placed before the DLC, my lord.
Hmm.
It may be placed before the DLC.
DLC.
So, sorry, my SLC, my
Okay.
lord.
Yeah, we know that. That's what I'm saying.
Yes.
Art Miss S.B. Chaudhary, Learned Counsel for the petitioner. And Mr. K. Diori, Learned Government for respondent
One,
numbers
3 and 6.
1, 2, 3, and 6. B. Diori, sorry.
And put 4 and 5.
Mr.
Okay, whatever.
P.K. Bora, Learned Standing Counsel, Elementary Education Department for respondent numbers 4 and 5. Stop having regard to the grievance projected by the petitioner. The matter is taken up for disposal at this stage. Stop. The petitioner earlier approached this court by filing WPC number 5352 of 2023, which was disposed of by order dated 18/9/2023 by directing the respondent authorities concerned to place the case of the petitioner before the district level committee, Karimganj, for consideration of his case for compassionate appointment. To stop person there too. The name of the petitioner was placed before the DLC concerned, and the DLC held its meeting on 15/6/2024. To stop in the said meeting, it was observed that since there was no vacancy under the prescribed quota of 5% in the cadre of grade 4 under the establishment of District Elementary Education Officer Karimganj, the name of the petitioner was recommended to be appointed against the admissible vacancy in grade 4 post in any other administrative department in terms of paragraph 15 of the Government's Office Memorandum dated 1/6/2015. Stop. The name of the petitioner has been placed at serial number 3 of the said meeting minutes. Stop. Despite the said recommendation, since the petitioner has not been considered, the petition is before this court. Stop. Mr. B. Diori, Learned Government Advocate, at this stage by producing communication dated 16/6/2025 of the District Elementary Education Officer, Sri Bhumi. What is this Sri Bhumi?
Yes, that Karimganj new name.
New name,
New name.
Sri Bhumi. Submits that, in fact, the case of the petitioner has been forwarded to the Secretary to the Government of Assam Department of School Education, bracket elementary, on 3/9/2024 for further necessary action. Full stop. Having regard to the submissions made by the Learned Council for the parties, and on perusal of the communication produced by Mr. B. Deori, the writ petition is disposed of by directing the respondent authorities to consider, no, to place the name of the petitioner before the next state level committee meeting for considering his appointment on compassionate basis in terms of the recommendation made by the DLC on 15/6/2024. The Secretary to the Government of Assam,
Yeah.
the School Education Department, respondent number 4, shall ensure that the name of the petitioner is placed before the next SLC sitting. All right. Boss. Would you like to take back this?
No, that may be a part of it.
Okay. The communication dated 16/6/2025 produced by Mr. B. Deori is retained in the record and marked as X for identification.
Item 8.
May I have your lordship? My lord, your lordship asked me when I prayed for interim prayer, my lord, your lordship has asked me why I need, my lord.
Lordship has refused to issue interim
the
pay on last occasion and
last
it is fixed
occasion.
today. So notice should go at this stage, Lordship, no is a.
My lord, I was praying for interim order only because, my lord, the list has been prepared and in that list, my name is not there. I have brought the list for your lordship perusal.
I have forgotten what is the case about.
This was for the, my lord, and I was debarred for applying to the post of headmaster due to not having the NOC for procuring my higher education. That is the core issue, my lord. And
DPU
also I have not been, I have been deprived of holding the post of in-charge principal of my school, my lord. So at this stage, I shall pray for notice, my lord, and my lord, I will pray that one post of headmaster in Bishwanath district may be kept, my lord, for vacant.
My
That
lord,
is my simple prayer, my lord.
that will cause prejudice to the person who were already been selected in the upgradation list, Lordship. Those were selected for the, they were not made parties in this petition. So the keeping a post vacant, that will prejudice those candidate, Lordship. So notice to go, Lordship, at this as interim may be continued at the next date, Lordship. Let us. So it will come today.
The status
Because some
quo,
persons has already been selected and final graduation has already been prepared. They were not parties before the honorable court, and now he want to keep, want the post to be kept vacant, that they will be deprived of their chance of getting promoted also.
the status quo as on today, my lord, with regard to the selection will be maintained, my lord.
And he was not selected because the department person notice had been issued to him why DP should not be initiated against him, Lordship, because he had not obtained any prior permission while obtaining his degree, Lordships, in a higher degree.
These,
Okay, that part is okay. Then
Yes.
the other part regarding the filling up of this or
Post of
appointing
headmaster.
somebody, yes.
The
What
headmaster.
is the process?
That district-wise Lordships graduation list has been prepared. Initially, a draft graduation list prepared. Whether if somebody has any objection, they can file objection within 7 days. Whether he has filed it or not, that is not pleaded here, Lordships. He has not filed anything,
No,
any
madam.
objection. Then Lordship final graduation is prepared and it was sent to the director Lordship for select for interview and post.
This is for the
and
post
if-
of principal,
headmaster.
headmaster,
And if there is 10 posts, then
on
2:1.
in-charge basis or on regular
No,
basis?
Regular basis.
Regular basis.
So,
So what is the process like? They prepare a gradation list,
initially a draft graduation list
draft.
within district wise.
Then
Then if somebody has any objection, they can file an objection within 7 days. Thereafter, Lordship, final graduation is prepared.
yes,
And
then
then also they can file objection. There is a time period of 7 days. And then the graduation list, if there is a
10 posts, then 20 number of person has been selected and send the list to the director lordship, 2:1.
Okay,
And then director will call those candidates for interview, and that selection will be made thereafter.
so it's on the basis of interview.
It's a based on the interview, get only select.
So where's the number of vacancy will be called?
Yes.
10 posts means 20
10
candidates will be
20
called.
candidates, yes,
And on the basis of the interview, they'll be placed as
yes.
headmaster.
On the basis of garrison list, people will be called, and on the basis of interview, they will be given. Now he has options
This
to
is
file an
actually,
objection at that when the draft list was prepared. The no objection has been filed. Now, if you want to keep a post to be kept vacant, lordship, those persons who were already in the final garrison, they will be prejudiced, lordship. They are not before this honorable court.
So how many posts are there now to be filled up?
That
42, my lord.
Huh? 42.
42.
Where is that?
That I don't have that instruction.
My lord, I have got the list, my lord.
No,
Selected.
why didn't you incorporate that in the writ petition?
It was not available at that point of time, as your lordship has asked.
You file it by an affidavit.
As
Will
your
issue notice only today. Mr.
Interim notice on interim prayer, my lord.
Heard Mr. B. Prokashta, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the communication dated 19/12/2023, bracket annexure 15, by which the petitioner has been said to have violated Rule 13 of the Assam Civil Service, within bracket conduct rules, 1965. For not having taken prior permission before pursuing the B.Ed course. The learned counsel submits that because of the said communication, the petitioner is likely to be not considered for the post of headmaster of secondary school,
Yes.
despite the fact that he is one of the senior most teacher.
Eligible.
Eligible or not, that will be decided by the department at the time of.
Next, para, issue notice of motion returnable by 3 weeks. Mr. S.M. Chichistry, learned standing counsel, secondary education,
One,
accepts
two, and three.
notice on behalf of respondent numbers 1, 2, and 3. Petitioner to take steps for service of notice upon the respondent number 4 by registered post with ADU within 3 working days. Next, para, also issue notice on the interim prayer, making it returnable by 3 weeks as well. List the matter again on Swansea.
Yes, lordship, item 18 and supplementary list 2020, same matter, lordship. Item 18 of this part 1 list, last item, and item 20 of supplementary list, similar matter, lordship, and the same concept is appearing.
Position same, respondents, everything.
Position is different, my lord. In that, my lord, case, I have been included in the gradation list. Thereafter, shockers has been issued. Now they are deciding to delete my name. That is the
Notice.
vice versa.
Okay, will just give me the file. 18 and what?
18 and 20 of supplementary list.
18 and 20.
Hello.
Hmm. Item 18, which one, what have you challenged? Annexure?
My lord, item 18.
Annexure 17, I think.
Yes, 17, 15, my lord.
17 is at page number.
17 is the shockers notice, page number, my lord, I'm giving. 149.
Page number?
149.
Then any other?
This
And-
is the main, my lord. Due to the issuance of the shockers, my lord, I have been now, though my name is there in the list, my lord, I may be deleted, my lord.
And
They are going to delete my name.
on
That is
apprehension.
the, not
Okay.
apprehension, my lord. This is a
No
shockers
action has
notice.
been, Sokol notice, but
Shockers
that
notice issued, my lord, about to be deleted.
That is his apprehension, Lordship.
Not
Anyway,
apprehension.
notice should go.
Anyway,
Now,
same
no,
order will be
that-
there.
yes.
Same order, my lord, but one thing, my lord, your lordship, because this honorable court has already settled this position, my lord. So in that event of decision taken, they might take the recourse of the judgment of this honorable court in the given in the Contractual.
That decision is yet to be taken, Lordship. Now on preemption, Lordship, he want to take a direction from this honorable court, Lordship.
Certain,
department
certain
take a decision.
parameters, my lord, certain parameters have been
Let
laid
the
down by
department
this
take the
honorable
decision,
court.
Lordship.
And that is the basis for determining the show cause notice. This observation will do the everything, my lord.
Now let notice go. If anything
Notice
happen, then he can come to this honorable court
Already
again
this
within
court has already
within
given the
higher
parameters
Lordship.
for deciding the show cause notices, my lord, disciplinary proceedings in certain cases, in this of page number 77 and to 101, my lord. That parameter is just.
Now on
That's
appeal,
all, my
Lordship,
lord.
he wants a direction from the honorable court regarding that parameter, Lordship. Only that notice was issued.
We'll
No extended
consider
decision.
that on the returnable
Yes.
date. Same order, okay? Same order.
I'm on good faith.
And show cause notice will be dated 10/4, no, 10/4 or 10/9?
Show cause notice, my lord. Annexure 17 is a 10-4.
10/4/2025.
2025.
Show cause notice dated 10/4/2025, bracket annexure 17. Rest is same. Item 18.
Item 20, Lordship.
Now, item 20, where's the show cause?
Show cause, my lord.
I think page 144, annexure 15. Now, how many show cause notice are there? There are two.
Two, my lord.
149 and 50 is the last of us.
What is the name of the petitioner?
Gitanjali.
Gitanjali. Gitanjali. That is, I think,
149, my lord.
149. Okay. Show cause notice is dated 10/4/2025, bracket annexure 17A. Remaining the same. Yes.
Item 9,
Let please, your lordship. This honor before lordship, the LP school teacher, my lord, who was appointed in the year of 1989 and completed basic training in the year of 1992. And my lord, he's also paid the scale of pay. And from 2007, his salary was stopped. He came before the honorable court along with others. Honorable court directed to pass an order by giving the salary current and arrear from October 2000. In the meantime, contempt petition is pending till today. In the meantime, my lord, government filed given a appointment as a tutor, pays 15, my lord. 79, my lord. My lord, petitioner before lordship challenged some condition, page 79, last para, my lord. You also got it, my lord. Page 79. And
What are you challenging? in this
challenging
petition?
the condition of the appointment as a tutor, my lord.
Page 79.
Page 79.
What is the condition?
Condition is the accommodated tutor will get prospective effect from 1/11/2020 only, and she cannot claim any benefit whatsoever in respect of past service rendered by him or prior to 1/11/2000.
This is a appointment.
This the my lord, fresh appointment is given as a tutor without cancelling the earlier appointment letter, my lord. And so many cases are, my lord, is filed, my lord. Their notice was issued in different honorable court.
You are accommodated as
As a
tutor.
tutor, my lord. We
What-
cannot, because of that, we have completed basic training.
Prior to this, what were you?
My lord.
Prior to this, what were you doing?
But I am as a teacher, I am continuing. And salary was stopped in the year of 2007.
Hmm.
And we come before the honorable court pass an order to give the salary. In the contempt petition was pending, in the screening committee was going on, and thereafter they issued this fresh appointment order by putting the condition that the prospective effect 1/11/2020 and cannot claim benefit whatever is past service, my lord. That is challenged before lordship.
How many petitioners are there?
Only
Here?
one, my lord.
Okay.
And my lord, after appointment letter, my lord, so many petition was also filed. And one of the cases, government go to the division bench, and division bench set aside that my lord, tutor appointment pays, my lord.
This is the first time you're coming?
Yes, my tutor challenging first time, earlier the second time, my lord.
Huh?
I am come before the honorable court, my lord.
Earlier.
Earlier.
Where's that order?
Well, please may kindly see.
Where's the order?
Hmm?
Where's the order?
Page 60. Page 60. And my petition is, my lord, 71, my lord.
These are common order.
Yes, my lord. Page 71, my lord. My name is there, my lord. Page 71, shell number 2. Hemkanto Hendik, my lord. And operative portion, your lordship, go to, my lord. Page 75, my lord.
So there were three of you.
No, only one, my lord. Can't refer to only one.
Earlier, there were three of you.
Three of
Oh,
petitions.
that's what I'm saying.
My lord. And my lord, content petition pending and scanning committee is going on. Thereby they give it by my lord this appointment.
Okay, tell me, why did you come earlier? Oh,
Earlier come
what
for
was your
non-payment,
grievance?
non-payment of salary
Non-
from October 2007.
You're working as teacher,
As a
assistant,
teacher, ma'am.
assistant teacher,
Assistant teacher from
LP school.
LP school and appointed 89, 92 I completed the training and give the time scale of pay, regularly receiving salary 2007. Now thereafter I'm gonna stop salary 2000.
Now, what was the direction pass?
Direction pass, lordship. Page para 9 minus.
Para 9, does it cover your case?
75 minus.
No, para 9 is for some other writ petitioner.
Some other repetition and para 8 minor.
Your case is 2996.
Minor.
2996 is
Minor
covered by
para 8, para 8.
para 8, yes.
Para 8. Having regard to the division bench judgment and the judgment in the aforesaid writ petitions, this court is of the opinion that petitioner in WPC number so-and-so, 2996 2015 are entitled to salary current and area commencing from September 2 and October 2007 as may be applicable. The other issue with regard to the early termination order stated to have been issued by the respondent authority, this court would not venture to decide upon the same, leaving it open state respondents to proceed deems it fit in accordance with law. Payment of it, other requests. So, my lord, contempt petition pending, and thereafter this order has been passed. And similar issue came before the division bench. Division bench order, my lord, page
Before that,
987.
just a minute, just a minute.
Just I'm praying before the.
Please wait for a minute.
My lord.
This is your first writ petition,
My lord.
and your claim was for back the salary.
Salary.
Then court directed you'll be given salary.
Salary.
Insofar as the termination or whatever is concerned, that will not court will not look into it.
My lord.
Then why did you file contempt?
Contempt because they did not.
Salary was not given.
Not given, willful and deliberative violation of the honorable.
Okay, then contempt is disposed of.
No, still pending.
Still pending.
My lord.
And in the meantime, what have they done? They have paid you.
That tutor was appointed, my lord.
This appointment at page annexure 15.
15, my lord. Because of the, we are not receiving under compulsion in my lord, we have going to that receive this order, but that.
But what about your salary?
Salary, salary I am receiving only now it tender from 2000 to 20, my lord. We receive on 1/11/2020 onwards. We receive on 10,500.
No, the earlier writ petition court said that you are supposed to get your salary from September, October 2007. That is not given till now.
Till now.
And what is that writ appeal?
Writ appeal in respect of same issue, honorable court directed to same honorable court to my lord. Same order was.
Who filed writ appeal? State.
State has been filed appeal.
What is this against this judgment?
Against the tutor, against that single bench
Okay,
order.
that is pending till now.
And no, already disposed of.
How it was disposed of?
Disposed of, set aside that, but you cannot now be given the tutor, my lord. Please may kindly see page 89, my lord. Page 88, my lord. And onwards 87, my lord. Can I read this, my lord?
The writ appellate also court's order.
Court's order, my lord. Page 88, my lord.
Just a minute. 22. No, but this is not your case.
The case is same, my lord. That is also given a non-payment of salary.
No,
1728.
just a minute. The order itself says that it's against the order dated 22/1/2019.
My lord.
Your writ petition was disposed of on 19/1/2017.
Oh.
It's not similar.
The tutor is concerned, para my lord, para 3 my lord, your lordship got it. May I read, my lord? It is noticed that during the pendency of the appeal, Learned Standing Council for the Elementary Education Division drawn the attention of this court regarding order dated 31 to same day order hour, whereby the respondents has been accommodated a praise as a tutor on a purely temporary basis on fixed salary of rupees 10,800 per month. Similar given, my lord.
Similar means what?
Similar means a tutor, my lord.
That is regarding the subsequent events.
Yes, my lord.
What I was asking you is about the order passed on 19/1/2017.
Our case is passed on 19 my lord. Our case is
19/1/2017.
yes, my lord.
Was it challenged?
Not challenge.
Not challenged.
No challenge. I am
Then you file contempt. Contempt is still pending.
still pending.
While pendency of the contempt, they have passed this 31
Yes,
2021.
given the tutor, my lord. And by putting the condition that you cannot claim in other past service.
But why have you challenged this now?
Because of that, it's my lord.
After 4 years?
My lord, yes, my lord. So many judgments are there. If in arbitrary clause putting the any appointment or any order, that can anytime they can be sent. But today I am not taking this judgment, my lord. If I to permit you next admission, and also we have no any bargaining power because of the under my lord. I am taking this.
Oh, no, leaving all those things aside, I'm asking you,
Right.
if order of 2021 was not to your liking, why didn't you challenge it immediately? Why are you coming in 2025 now, after 4 years?
But one thing is that that judgment is always says that my lord, at any time you can propose to be if the arbitrary clause is given, my lord. And that judgment today I'm not taking other cases. So many similar issues, so many cases are.
We'll issue notice only, that
Not-
much only.
Yes, ma'am.
Part Mr. N. Bora, Learned Counsel for the petitioner who submits that by filing this writ petition, the petitioner has challenged the order dated 30/1/2021 bracket annexure 15, by which the petitioner has been deprived of his past service rendered as assistant teacher in LP school. Full stop. The said appointment has been made in the post of tutor and with prospective effect from 1/11/2020. Next para, issue notice of motion returnable by 4 weeks. Miss
And
N. Fukan, Learned Standing Council, Elementary Education,
yes,
accepts notice on behalf of
fine.
respondent numbers 1 to 5. Who is the finance department? Finance department, anyone? Mr. A. Chaliha, Learned Standing Council, Finance Department, accepts notice on behalf of respondent number 6. Stop. Notice is therefore complete. Petitioner shall furnish requisite copies of the writ petition to the Learned Councils appearing today, within 2 days. List again.
Tendency no but to consider the case of the petitioner because our consideration is there, my lord, page 86, my lord.
Where is that?
Page 86, my lord. My lord, they did
How
not
you considered?
consider because of I am completed basic training, but they did not do it, and my lord, authorities, my lord, please make at least page 86.
What is 86?
86, my lord, a communication issued by the district elementary education officer to director elementary education regarding, my lord, newly accommodated tutors for my lord regular time scale of pay as completed basic training. With reference to the subject cited above, I have the honor to forward here with a petition submitted by the following 4 members newly accommodated tutor block elementary education. The concern of petition I have prayed for allowing enjoy regular time scale of pay as they had already completed junior basic training. So my name is there, serial number 1, man. So I'm praying before pendency is over to consider, man.
Next para, having regard to the communication dated 5/1/2022, bracket annex 18, made by the District Elementary Education Officer, Lakhimpur, to the Director of Elementary Education, pendency of the writ petition will not be a bar for granting the regular time scale of pay to the petitioner.
Much fuller.
Item 10.
May please.
Well, before I take your lordship through the documents, may I just briefly indicate, the fact are slightly longish.
Yes.
What has happened is, your lordship is aware under the Right to Education Act and the rules, there is a requirement of for maintaining to give effect to the provisions of the act and particularly maintaining the student-teacher ratio, etc. Under the rules, there is a provision that a permanent cadre of teachers will be created under Rule 20. I'll place that. If your lordship so desires, I can place the provision straight away. Madam. If your lordship takes up the rules for a moment. Madam.
What is the case regarding provincialization?
What has happened is, instead of going by the mandate of the act and the rules of creating a permanent cadre, they appointed us after a selection. They appointed us on contractual basis, right? After the appointments were given effect to, we have been agitating that we are entitled to be regularly appointed because we have faced a regular selection process. There are repeated directions from this honorable court, interim protections granted. A move was initiated in 2023. We were asked to give an option whether we would like to be regularized prospectively, giving us the initial pay, or we continue as contractual teachers. We challenged that. There is an interim protection given to us. Thereafter, a second move was initiated, an advertisement was issued for the process of regularization. That again we challenged, again at the initial pay. That has been stayed. Now comes this, my lord, impugned action. In the meantime, what has happened? All these contractual teachers, since they have been appointed way back in 2012, many are the senior most in the respective schools. They have been allowed to continue as headmaster. Now comes the, my lord, impugned order. If your lordship will kindly come to page 79. First, there is an SOP issued.
You're challenging this?
Well, this page 77 and 79 and 84 are under challenge. Basically, why these three documents, what they are seeking to do is completely ignore our existence. We have been continuing as headmasters, each of the 5 petitioners. Our cases do not even find mention in this one. So what will happen is, people who are junior to us will be made headmasters by ignoring us. Well, in fact, may I place the facts from the beginning? That will make the position.
Yes.
First, your lordship will come to I have annexed one of the appointment orders.
How many petitioners?
5.
5 of you.
Your lordship will kindly come to page 41. And this position is not in dispute at all. The fact that we have faced the regular selection. Page 41 is the appointment order of one of the petitioners. In pursuance of the provisions of the Right to Education Act 2009, and as per the advertisement number so-and-so dated so-and-so, the following candidate is selected by so-and-so Assam for engagement as assistant teacher in lower primary schools in Nagaon district of Assam, purely on contractual basis. Your lordship will kindly note this one. And if you're now if your lordship takes up the rules, right of children to, or
what is that?
I can, your lordship may have this. What is it?
Act.
2009 Act. Under the Act, there is a set of rules framed of 2010.
Rule number?
Rule 20.
Salary.
Salary and allowances and conditions of service of teachers. The central government or the appropriate government or the local authority, as the case may be, shall notify terms and conditions of service and salary and allowances of teachers of schools owned and managed by them in order to create a professional and permanent cadre of teachers. Your Lordship will kindly note this word. And sub-rule 3 says the scales of pay and allowances, medical facilities, pension, gratuity, provident fund, and other prescribed benefits of teachers shall be at par for similar qualification, work, and experience. There is no doubt that the qualifications, etc., is exactly the same. Now, first they make an appointment on contractual basis. Then, my lord, this is what they seek to do. If your lordship, we said that we are entitled to be regularly appointed. There is a protection granted by this honorable court at Annexure 7, my lord, page 66. And this writ petition is still pending. Page 66 it starts. If your lordship will kindly turn to page 69. Third para from bottom.
Yes.
In that view of the matter, as an interim measure, let proportionate number of posts as the number of petitioners in the elementary education, lower primary government of Assam be kept unfilled, which may not be filled without the leave of this court. Now, this protection is granted. The next mischief they do is...
Now, who are the petitioners here? The same present petitioners.
No, madam, this is other similarly placed persons. Yeah, without I guess. Similarly placed, but there are several writ petitions pending. One. There are about 2,000-3,000 odd persons similarly placed.
Regarding the pay.
No, that contractual service. When the selection was made, about 3,000 odd teachers were appointed on contractual basis. So there are a large number of writ petitions pending. Some claiming regularization, some challenging the next document that I am about to place. What they sought to do.
No, what is the case that they should have been appointed on regular basis?
Exactly.
Not on contract basis.
Not on contract. Because the act itself provides for a permanent cadre and identical pay and allowances. Now, when this writ petition was pending, they come up with the second move. Today, an additional affidavit has been filed. If your lordship will kindly take up the additional affidavit. At page 97, what they did was, all arm twisting methods. What they do is, they give us an option that either you opt for regularization prospectively, or you continue as contractual teacher. With reference to the subject cited above, I am directed to enclose herewith the model format of options for the contractual teachers and the state pool teachers working under Samagra Shiksha Assam, presently working in the elementary schools of the state. The said category of teachers are to voluntarily opt for regularization of service with initial pay benefits from the proposed date of joining that will be fixed in due course of, or to continue as contractual teachers with the existing financial benefits and service conditions. Well, the choice is between the devil and the deep sea. So naturally we challenge this, and the order passed is at the next page. Again, several writ petitions were filed. The operative portion your lordship will find at page 100.
This was challenged.
This was challenged, the option given. Because that was clearly, my lord, arm twisting tactics is adopted.
Okay, says just a minute. Voluntary opt either for regularization or service with initial scale pay benefits from the proposed dates of joining.
That will be fixed in due course, which means, my lord, if I opt for this, all my past service gets wiped off. So the date of joining, once I exercise the option, the date of joining that will be assigned to me. From that day, I will be entitled to and that to pay scale at the initial level. Or I continue as contractual teacher. So this was challenged, my lord, when page 98, this was by the association.
Yes.
And page 100, paragraph 5 is the order. as this court had earlier passed an order on 25/1/24 in WPC number so and so and other connected matters and the pending IAs that the instructions in the communication dated so and so will not automatically be applicable in respect of those petitioners who are rendering their services as contractual teachers under the said pool teacher, and it is submitted that the petitioners herein are also suitably situated. It is directed that the petitioners will not be compelled to submit this option in terms of this communication by the timeline fixed, which is so and so. So we could not have been compelled to exercise this option. Then
No.
what they do is,
You are a part of the association.
yes. Now, next page, once this is, my lord, stayed by this honorable court, they come up with the next move, which is at the next page, man. With a view to support, strengthen, and improve the quality of elementary education in the state of Assam and in pursuance of government approval so and so, and in exercise of powers under the Assam elementary education so and so rules, online applications are hereby invited from willing and eligible candidates who are working as contractual state pool contractual teachers under so and so SSA through the official website of so and so for filling up of 35,133 so and so teachers, upper primary and science graduate teachers in upper primary, etc. in the initial pay band. Your Lordship will kindly note this one. Once again, they come up with this that you have to join, you will be treated prospectively, basically. Initial pay band means all the increments that I have received in the past, everything gets wiped out. My past service gets wiped out. Once again, we challenge this one. And the order passed is in the main writ petition. It's at page 73 of the writ petition. Starts at 73. This is again by the association. And the operative portion, your Lordship will find at page 75.
Yes.
In the interim, the advertisement dated 6/8/24 issued by the Director of Elementary Education inviting online applications from contractual and state pool contractual teachers under SSA for filling up of 35,000 etc. posts of assistant teacher of lower primary so and so shall remain suspended till the next returnable date. This writ petition is again pending, man.
6/8/24. But the annexure you showed me is 5/8/24.
That there might be a mistake with the dates, madam.
No, this says online. This is also online.
Online. It's the same advertisement. The date perhaps is wrongly typed out.
But it means this 5/8.
Mark.
Okay.
Now, what they have done is this one. In the meantime, I must point out another factual aspect. Since we are, by virtue of our length of service, in our respective schools, we are the senior most. And therefore, we have been allowed to, that we have made a categorical statement at paragraph 3 of the additional affidavit. We have given a chart, in fact, the dates from which each of these petitioners have been allowed to hold the charge of headmaster.
Oh, currently you're holding the charge of headmaster.
Headmaster. Because we are the senior most, although on contractual basis. Now, they tactfully issue this impugned, my lord, standard operating procedure. And your lordship will find on a reading that very tactfully, we have been completely ignored. What will happen if this is given effect to? What will happen is someone who is much junior than me will come in and I'll be replaced. The Director of Elementary Education Assam is in the process of upgrading senior most assistant teachers to the position of head teacher. In lower primary schools, district elementary education officers have submitted relevant teacher details for their respective districts. Based on these submissions, the Director of Elementary Education Assam has initiated the upgradation process. However, during verification, certain complications have arisen that require clear guidelines for smooth implementation. The standard operating procedure has been developed to resolve these issues and streamline the process. SOP guidelines, seniority calculation. The school-wise seniority of teachers will be considered for upgradation to the post of head teacher. appointment date of SRD teacher. Teachers recruited under special recruitment drive. This is that, my lord, option that was asked for. What this honorable court said was the people cannot be compelled. So some people exercise the option and they are being called special recruitment drive teachers. Now what they say is this one. Teachers recruited under special recruitment drive will have their seniority counted from the date of their new appointment under the jurisdiction of the Directorate of Elementary Education. So they come in. Exclusion of contractual service. The contractual period of SRD teachers will not be considered for seniority. Resignation undertakings of so-and-so we are not concerned. Interim head teacher arrangements, the DEO so-and-so will appoint an in-charge head teacher in schools that lack a regular head teacher. Upgradation of SRD appointed senior most teachers. If a school has no regular teacher and the SRD appointed teacher is the senior most, they will be upgraded to the post of head teacher and their previous position will be automatically abolished. And rest we are not really concerned. What I wanted to point out is the contractual teachers do not find any mention at all. So which means we will not be considered at all. We'll be completely ignored.
Point number 3 says exclusion.
Exclusion. Even those SRD teachers who have opted, their past service of contractual service, that is also being ignored.
You don't belong to the SRD.
No, because we did not exercise the option. Because there was a protection granted by this honorable court.
Special-
Our claim is that from the date of appointment, we ought to have been, because the rules provide for a permanent cadre, we ought to have been regularly appointed. We could not have been appointed on contractual basis. Now, following this notification is issued, my lord, at page 79. This is also challenged.
What is the date?
29/4/25. In the interest of public service, the services of additional teachers recruited under special recruitment drive and regularized thereafter by the government in the Department of School Education shall be benefited with the following. Past services of the teachers shall be counted only for granting transfer under the Teacher Transfer Act. The teachers regularized under the special recruitment drive can avail the benefit of single transfer with post as nature and type of the post is different. The teachers regularized under so-and-so can become headmasters of the LP UP school. So since they exercise the option for regularization, they are being considered for headmasters. So even assuming a person who has been appointed on contractual basis after me, but he exercised the option, now he can become a headmaster at my cost. Then if your lordship kindly turns to this actually finally gave rise to the cause of action, page 84. Annexure 14, page 84. This is also under challenge. With reference to the subject cited above, I am to forward herewith list of LP schools for upgrading senior most assistant teachers to head teachers in LP schools as per Annexure 1. You are requested to return the said Annexure 1 filled up so-and-so column, so-and-so grade pay urgently by 19 June 25, the scan copy, hard copy, etc. So they have now initiated the process to give effect to this SOP and the impure notification. So therefore, my lord, my respectful submission at this stage is clearly as per the act and the rules we are entitled. Clearly there are interim protections granted by this honorable court where this honorable court is examining each of these issues. Our entitlement to regularization from the initial date of appointment, etc. Well, at this stage, to topple the apple cart, my lord, when I am already holding the post of headmaster, to remove me, it will be a little too unfair. Your lordship will issue notice and stay these notifications. Otherwise, what will happen is abruptly someone much junior than me will be appointed in my place.
What are those cases which are pending?
All of them are pending. In some,
One you have shown me, which is at page 68 on this writ petition. This is one case.
I'm sorry, madam.
7223.
In fact, there are a series of writ petitions filed individually also. Associations have also come. But the ones that we have filed are, my lord, two. The association. One is WPC 439 of 24 and the other one is 4031 of 24.
304.
4031 of 2024
4031.
of 2024, and the other one is 439 of 2024. 439 challenging that option, 4031 challenging the advertising. These two are by the association. And since, my lord, this headmaster issue does not affect the entire association, that is why we have come in individual capacity.
This SOP also does not affect just the headmaster alone.
We are
Everyone.
completely ignored. Our cases do not even find mention in the SOP. In the entire SOP. Your lordship will find contractual teachers are not even mentioned in this. It is only the SRD teachers whose contractual period is mentioned, but contractual teachers are not even mentioned. So they indirectly what they are trying to say is you did not exercise the option and you went to court. So this is what we will do to you.
Where is this other case? 4031.
The order passed is at page 73. Relevant portion at operative portion at page 75.
This is an association of LP school teachers on contract basis.
Contract. But what has actually happened is, since now this aspect of headmaster does not affect the entire association, that is why we have had to come individually.
Where's the advertisement? 6/8/24.
Advertisement, that is in the additional affidavit.
Additional affidavit.
That is the page 101 of the additional affidavit. But perhaps the confusion regarding the date has happened because of serial number 3, madam. And your lordship will kindly see how nasty they could get. 5th of August they issue this. 6th of August, 10 a.m. is the last day. Next morning. Not the last day. And midnight, they commence, and by 12th it is over.
At this stage, let us bring our instruction, madam. Let us bring our instruction.
Will issue notice? Heard
And
Mr.
state this entire.
Heard Mr. I. Chaudhary.
In the interim, my lord, notice may go, my lord.
Lordship, may I, sir? Sir. I'm referring for SSL.
Hmm.
Lordship is clearly seen two types of teachers are there. One, contractual teacher. Contractual teachers are under SSL.
Hmm.
And one, those who have been regularized, they're under the law network. Now, these contractual teachers have no such right that their services has to be regularized. There is no such rule. It's a policy of the government.
Hmm.
Government took a policy that these contractual teachers shall be given the minimum of the pay scale, that is the entry level pay scale, and accordingly their services shall be regularized. And it is the settled provisions of law that regularization is always prospective. That is the law. Now these teachers, they have decided not to follow the SOP and not to follow the law, the procedure. That
No,
has
but
been-
SOP does not include them.
SOP is subsequent laws. SOP is subsequent. Initially, the policy of the government that has decided to regularize the contractual teachers, particularly citing the condition that their regularization shall be prospective. That is the condition. That is first, Lordship. That is the law, Lordship. Regularization is always prospective. Let them show one judgment, Lordship, wherein it has been held that no,
But what about the past service?
past service, that is under me, Lordship. That is contractual service under SSA. That is not under government. Once the government accept their service under government whole, Lordship, government is entitled to fix the conditions, settle the conditions. This is the prerogative of the government. It is their policy, no rule, Lordship. If they can show that this is the rule under which my service has been regularized, they can say that under the service rule, I should have been given the past benefit, counting even my past services.
No, they are not regularized as yet, isn't it? They are on contract basis, even as on today.
Initially, they were regular. Initially, they were contractual contract basis. Government decided to regularize their service at the entry level pay scale, not giving even the full scale, at the entry level pay scale. Government also decided that yes, you will be given the seniority, but only from the date when you enter.
That is under consideration, isn't it? As on today.
In the writ petition, that order has already, your Lordship has passed. One order is already there.
No, which is that?
Now, if Lordship comes to the additional affidavit, Lordship, page 100. That is the order passed in the writ petition. That one protection has been given that they shall not be. It is directed that the petitioners will not be compelled to submit this option in terms of the communication by the timeline fixed at 31/2024, page 100. So that order is already there. Now today they have filed this additional affidavit, Lordship. Today morning only at 10:59 I have been given copy, Lordship. Why, for what purpose this has been filed, Lordship? To bringing on record certain relevant facts and documents which are necessary for the proper adjudication of the case. What are the documents, Lordship? It's a document of 2024. So initially they failed to get the order they were trying to get. And today by filing this, they are trying to obtain a stay order. Lordship will simply issue notice in this IA, Lordship. Where is IA? This is the additional affidavit, Lordship. And in the main case, Lordship has already issued notice. Let the department file their reply, Lordship. Lordship will adjudicate the case.
Now, what do you mean by main case?
Yes,
It has come for the first time today.
Main case means what?
in other cases, Lordship, one
Yeah.
similar order is already there.
There are two other cases pending
Similar order is
filed by the
already there.
association.
Those two are entirely cause of action itself is different.
No,
The
all-
first interim order is with regard to the option that was asked. That either you continue as contractual teachers or you can opt for regularization, but prospectively. That is under challenge, which issue is being examined by this honorable court. And there is an interim protection that these people cannot be compelled to exercise the option. So some exercise, and we did not. We did not because the issue itself is under examination by this honorable court. Our claim is that we are entitled to regularization from the initial date of appointment. Because past service, my learned friend said, let them show us judgment. It's a well-settled principle of law. Sub-Inspector Ruplal's case, the past service cannot be obliterated. If a due process has been followed, the past service has to be, that benefit has to be given
The earlier service was under SSA.
under SS
Now they are trying to bring you in under the government.
government.
Correct.
Because the mandate of the law
Hmm.
is, I am not taking your lordship through all those documents. The mandate of the law is under Rule 20 and also the state rules that it has to be a permanent cadre and same service benefits, including pay scales. Rule 21 and 23. The whole mandate of the law itself is that a permanent cadre has to be created. So when they made this appointment on contractual basis, that per se was violative of the rules. Therefore, we have staked a claim, filing a writ petition, and that writ petition is under examination by this honorable court.
That appointment dates back to 2012.
Well, so what will happen? What essentially they are now trying to do is there is a classification that has now got created. By virtue of this option, some people opted, others did not opt. Now, assuming hypothetically, and there are real instances also, I was appointed in 2012. A person appointed on contractual basis, let's say in 2016 or 17, only because he exercised the option, he will now replace me. Although I am already holding the post of headmaster
In charge.
in charge. And that in charge, your lordship is aware, my lord, Honorable Justice B.K. Sharma's judgment, that even while making officiating promotions, seniority has to be maintained. And here is a case where, let's say a person appointed in 2012, a person comes in sometime in 2020, only because he has exercised the option, he will now hold the post of headmaster and I will be languishing somewhere.
All right. Now, Mr. I. Chaudhary, Learned Senior Counsel, assisted by Mr.
SP Sharma.
S.P. Sharma for the petitioners, who submits that the petitioners were appointed as LP assistant teachers sometime in the year 2012, and they are one of the senior most teachers who are currently holding the post of headmaster on in charge basis. He submits that the petitioners, by filing this writ petition, have challenged the standard operating procedure bracket SOP for upgradation of senior most assistant teachers to head teachers in LP schools. Issued on 3/3/2025 bracket Annexure 11. The petitioners have further challenged the notification dated 29/4/2025 bracket Annexure 12. And also the communication dated 15/6/2025 bracket Annexure 14. Full stop. The Learned Senior Counsel submits that although the petitioners are entitled to be appointed on regular basis, having regard to Rule 20 of the Right of Children to Free and Compulsory Education Rules 2010, they have only been appointed on contract basis. And by issuance of the impugned SOP, the notification and the communication, the petitioners have not only been left out, and that an attempt has been made to place those who are junior to them as principal of the lower primary schools concerned,
Headmaster.
headmaster, solely on the ground that they have exercised the option as offered by the state government on 10/1/2023. This will be annexure 14, is it? Bracket annexure 14. Referring to the said communication, the learned senior counsel submits that the contractual teachers and state pool teachers working under the SSA are to voluntarily opt either for regularization of service with initial scale of pay benefits from the proposed date of joining that will be fixed in due course, or to continue as contractual teachers with the existing financial benefits and service conditions. So the learned senior counsel submits that going by the said offer, it is clear that the petitioners and other similarly situated teachers will have no right to claim their benefit of their past services. To stop aggrieved with the same, the LP School Teachers Association, under the name and style of Sadao Asom Prathamik Tet Utarino Shikshak Samaj and Samaj, had approached this court by filing WPC number 439 of 2024. And this court invite order dated 29/1/2024, having regard to a similar order passed in another writ petition, that is WPC number 7223 of 2019. Had directed that the communication dated 10/1/2023 will not be automatically be applicable in respect of the petitioners rendering their service on contractual teachers. Thereafter, the state respondents came up with an advertisement dated 5/8/2024, inviting willingness from eligible candidates working on contractual and state pool contractual teachers under SSA through official website of DEE Assam for filling up of 35,133 posts of assistant teachers of LP and upper primary and science graduate teachers in upper primary, etc. in the initial pay band of pay band 2 at the rate of rupees 14,000 rupees 70,000 plus grade pay and other allowances. Stop again aggrieved with the said advertisement. The LP School Teachers Association approached this court by filing WPC number 4031 of 2024 and filed interim order dated 12/8/2024 from this court while issuing notice had suspended the advertisement dated 5/8/2024. To stop, while the two writ petitions are pending for consideration, the respondent authorities have, on the basis of the impugn SOP and the notification dated 29/4/2025, has sought to regularize the teachers who had given their option.
Not only the regularized, my lord, even others who are, would be, might be junior than me would get a preference.
It
They
is the
simply
case,
ignored the-
it is the case of the petitioners that not only those who had made the option, had given the option, but even those who are junior to the present petitioners would steal a march over them for holding the post of headmaster of LP school. And therefore, the impugn SOP, the notifications and the communications should be interfered with by this court. Next para, in view of above, issue notice of motion, returnable by 4 weeks. Mr.
I'm PK Bora for one.
PK Bora, Learned Standing Council, Elementary Education. Department accepts notice on behalf of respondent numbers 1 and 2. While Mr. P. Nayak, Learned Standing Council, SSA, accepts notice on behalf of respondent numbers 3 and 4. Who is number 5? Manik Chandra Bora. Private. I'm sorry, no. Oh, that's a petitioner. Okay. As such, no formal notice is required upon the respondents. Petitioners to serve requisite copies of the writ petition to the learned councils appearing today within 2 days. Also issue notice on the interim prayer made by the petitioners, making it returnable by 3 weeks as well. Stop having regard to the projection made till the next returnable date as an interim measure. The respondents are directed to maintain status quo. List the matter again on 14/8.
Obliged.
Obliged.
Item 11.
May it please your lordship.
Yes.
The lordship matter is pertaining to lordship compensation or appointment lordship. Lordship in this case, my
First round, second round.
lordship first round lordship.
First round.
My name has been recommended by the DLC Borbera lordship. They are
Where is that page?
lordship 11 page number 39 lordship.
39.
Lordship, my name is serial number 3 lordship. Manoj Kumar Pathak lordship.
Manoj Kumar.
Manoj Kumar Pathak.
Yes.
Who's married.
Yes.
Applicant had applied within 1 year. Applicant passed SSLC and applied for any post. The proposal was placed in the DLC dated 7/2/2024 for discussion, and the DLC has considered his proposal for appointment of any grade 4 post under any department of his. The House unanimously decided to forward the statement of the candidate in order to accumulate the required data to Government of Assam Education Department, Dispur, Guwahati, so and so. Accordingly, SLC may consider his case for appointment him in any department if satisfied. Lordship. There are Lordship on 18 Lordship 9/2024 Lordship on office memorandum was issued by the Government of Assam Lordship. Whoever decided to not to place any matter before the DLC or SLC Lordship.
Any other department means that in the department concerned, there's no vacancy.
Yes, Lordship.
So it may be considered in
In
any other department.
We have Lordship on similar certain matter. Lordship.
DLC is dated?
Same Lordship, same.
No, when was it? When did the DLC sit?
Page number 31 Lordship. And excerpt 4.
7/2/2024.
24 Lordship.
Why is it called special DLC?
Lordship.
DLC Barpeta, is it? District.
Yes, Lordship.
Hmm.
Any similar order may be given.
What is this case? Abul Kalam Azad.
Lordship, page number Lordship 64 Lordship. Next, sorry. I mean next in
64.
64.
Oh, this is that bunch of writ petitions.
Yes, Lordship.
I see. Mr. Diori?
Lordship, here, your Lordship, on that perusal of page 39 itself, your Lordship. Perusal of page 39, upper hand it is said that vacant post nil. Then that before the petitioner, it is Aribinash Bayan, that is 1996. Your Lordship, date of death is 1996 and the petitioner is 2002. And on perusal of the same, that DLC list yourself, Lordship, in page 42. Matter of 2015. So, and again on perusal of page 44, it seems that matter relates to 2016. So, this or that pretext, those matters were not forwarded. So let's have, on this particular DLC, let me have a query with regard to this, because matter pertaining to 1996, 2002, all this were provided. Scheme itself very well speaks that hardness and immediacy. Your Lordship. So in this, by showing this pretext, they had six matters of 2016-15 were not forwarded. So just at least one date be given for
Lordship,
seeking some
Lordship
clarity.
had already disclosed one
That I do agree.
I'm
But
providing the
I'm praying before your Lordship to just, because we had the discussion with our colleagues, so just one date be provided.
Your Lordship had already disclosed.
Because sometimes it,
one in CL number 2 Lordship or even as
we come in puzzle state, your Lordship. Matter of 15, 16 are not being, and matter of 1992, 96, 8 are
Lordship in this case,
given
Lordship till
consideration.
2020.
This serial number 2, you have just pointed out.
Yes.
Business ban.
Arbinas Bayan.
Hmm.
We had passed one order the other day. Have you seen that?
Yeah, yes, but just
1996.
just a date can accommodate your Lordship. Only one date.
Your Lordship has already disposed of a similar matter.
That I do agree. I agree with all of the environments meeting.
Only Lordship direction may be given to place my matter before the SLC Lordship.
Because otherwise they will take it for granted, your Lordship. This one,
No, DLC has recommended, so
Same DLC Lordship.
SLC will consider it.
definitely, I'm
There
not
is-
saying that my friend will be obstructed, but
There is
just-
no such kind of positive direction that they, by hook or by crook, they should consider and appoint him. Ultimately, that order will come.
If that be so, your Lordship,
Hmm.
why do you have to that from 17 the scheme stop? Scheme speaks
Yeah.
about immediacy and harness. 16, 15 matters should have got that opportunity, your Lordship. So that's just
So
one
we
day.
don't know.
Hmm.
It is the action of the response.
Yes, that's right.
Lordship, in my case, Lordship, till 2022, Lordship.
I'm not
I am-
stuck in that. On next
I
day,
was
I
not
myself will
communicated
submit and will
any
review
Lordship
them, but just
information
accommodated
whether
one
my
day.
application was rejected or
I'm praying
considered.
for just
The
one
other
day
possibly
accommodation.
as per direction of the Lordship.
On immediate ensuing of the vacation, let the matter come on.
Heard Mr.
Jai Hatimuria.
J. Hatimoria, learned counsel for the petitioner, who submits that although the name of the petitioner has been recommended for appointment on compassionate basis by referring the matter to the state level committee, why the DLC district level committee meeting minutes for Barbeta district dated 7/2/2024, as he has not been considered by the SLC till date, the petition is before this court. The learned counsel submits that a case of similar nature, that is WPC number 2686 of 2025, bracket, Ari Binash Bayan versus State of Assam and 5 others, close bracket, has been disposed of by this court on 24/6/2025 by directing the state level SLC to consider the case of the petitioners therein. Mustap P therefore prays for a similar direction. Next para. At this stage, Mr. B. Diori, learned government advocate, submits that he may be given some time to get instructions in the matter. Considering the submission made, let the matter be listed again on so and so.
28-7.
28/7.
The Venice before 28 was sorted. Okay, Lordship.
28/7. There's so many cases fixed here and there, that's why.
Lordship, immediately after reopening of any date, Lordship, 15 or 16.
16 is Wednesday, is it? We'll have it on 16. 16.
Okay, Lordship.
Let's take a short break and come in.
Item 12.
Maybe.
Yes.
Lordship, this is a small matter, Your Lordship. The matter relates to Your Lordship, non-forwarding of pension particulars, Your Lordship, of the petitioner. What happened, Lordship? Petitioner was appointed as a regular principal, Your Lordship, who is retired on punishment of 31/7/2024.
31/7 of,
7 of 2024.
okay.
2024.
Retired as principal.
Yes, principal, regular principal. Before that, Your Lordship, I will to apprise this code that I was initially appointed as regular principal on 27/6/17.
Hmm.
Subsequently, my appointment has been challenged and by order dated 26/9/19. Passed in WPC number 42/3/4/17. My appointment has been set aside. The relevant part, Your Lordship, will find at page 23, Your Lordship. Maybe 17, para 17. In the result, the petition is allowed the appointment of respondent of 6, that is the petitioner, while order dated so and so is set aside. Consequently, the authority will hold a fresh selection process by considering all the candidates, including the petitioner, respondent of 6, in accordance with law. However, this is important, Your Lordship. However, till such exercise is completed, The respondent number 6 will continue to hold the post of principal purely on provisional basis. After exercising the lordship, resolution was conducted. Again, I have been appointed on as principal, regular principal on 31st of 7, 2024. This is page 24.
Yes.
So by virtue of my earlier appointment to lordship, I have been drawing the scale of pay of regular principal till I have been reappointed. Subsequently, also after appointing your lordship, I have submitted my pension particulars to your lordship to the in-charge principal who is now holding the post as a DDO, as he is the DDO, to forward the same to the IS Inspector of School, who will, your lordship, update the same to the pension portal of the department, your lordship, for its finalization. Now, this DDO principal in charge is not forwarding my application, saying that you have drawn excess pay during this intermediate period.
Between which period?
Between this provisional period, which I have been holding. Am I got it, lordship? Initially I have been appointed as a regular principal.
What is the period? Do you have the definition of that?
Yes, yes.
Give me the date.
20 initially appointment 7/7/17. I have joined earlier as a regular principal. Subsequently, my appointment has been set aside. Appointment order has been set aside
With
by
immediate effect?
yes.
With immediate effect?
No, this was by order dated 26/9/19.
Correct.
This order, lordship, I have been pointed out as page 23. Has been page 23, para 17, allowing the petition of other, my petition, my order date so and so is set aside.
Just a minute. See, the order dated 26/9/2019
19.
is an order by which set aside your appointment
My
order.
appointment order of.
Please listen. Please listen. Then you were asked to continue as on provisional basis, correct?
Yes, lordship.
Now, subsequently on 31/7/2024,
Yes, lordship.
you have been again appointed.
Again appointed.
So the period between this 2019 and 2024,
Yes.
you have drawn excess amount.
Yes.
Is that the case?
This is why, lordship, they are not forwarding my pension particulars, saying that verbal is, lordship, saying that you have drawn excess amount. So verbally only. No such a, lordship. My pay application is page 25. I have submitted several representations has been given to them only, but they have no authority, lordship, to examine whether this amount or that amount I have to take. Their only duty, your lordship, to forward my application, forward my pension particulars to lordship. And IS authority, your lordship, only to lordship upload my pension particulars. This is the department concerned. Department will verify, lordship, what excess amount, whether I have been drawn or not.
Where is your statement? You have been verbally informed that you have drawn excess amount.
Yes, lordship, it will fine with page 12, para 12, your lordship.
Verbally informed by whom?
To the petitioner, lordship.
To the petitioner by whom? It's very vague.
I will inform it.
Some voice came from somewhere and informed you that we will not give you.
Lordship, this is the principal in charge of the lordship.
Hmm?
The present principal in charge of lordship.
Where have you stated that?
He is the DDO here, lordship. He is to forward your lordship.
Yes, madam, what do you say?
Lordship,
You are for which respondent?
I'm for the department lordship, secondary education.
What is that department? Secondary.
Chief.
We issue notice then.
Dispose of directing
No,
them
Lordship,
to.
I need to.
How to dispose it of? Let them also respond.
They are only to lordship, only duty your lordship, only to forward your lordship. By access drawn or not your lordship, it is the concerned department, pension department that will examine your lordship.
See, unless the principal comes in forward and says that what is the reason behind, how do we say that you forward it? There might be some defect also. We don't know what with the defect. We'll have to issue notice. Your good name?
Eyes for where?
Heard Mr. I.S. Borbuya, learned counsel for the petitioner, who submits that the grievance of the petitioner is that despite having retired as a principal of Algapur Public Higher Secondary School, Hailakandi, on 31/7/2024, the principal in charge of the school, bracket respondent number 5, has not forwarded the pension papers of the petitioner to the inspector of schools, Hailakandi District Circle, for the necessary process. Next, I issue notice of motion returnable by 3 weeks. Miss
NM Sharma, Lordship.
N.N. Sharma.
Sharma.
N.M. or N.N.? N.M. Sharma, Lanet Standing Council, Secondary Education Department, accept notice on behalf of respondent numbers
1, 2, and 4, Lordship.
1, 2, and 4.
Lordship.
Pension. Mr. B. Deori, Lanet Governor Advocate, accepts notice on behalf of respondent number 3. Petitioner shall therefore furnish requisite copies of the writ petition to the learned councils appearing for respondent numbers 1 to 4. Stop. Petitioner shall take steps for service of notice upon respondent number 5 by registered post. Can you give by hand also, Dusty? By registered post ADDU within 3 working days, as well as by way of Dusty through the registry of this court. Stop. Once notice is served by Dusty, petitioner shall file an affidavit as proof of service. List the matter again on so and so. 11/8/2025. Stop. Pendency of the writ petition shall not be a bar for the respondents to process the pension papers of the petitioner.
13th,
Please, Judge. In this matter, my lord, petitioners are
Not maintainable, my lord. Submit it a prayer, my lord. This should have been listed before the division bench. The amended rules have been put to challenge. It's a issue to be adjudicated by the division bench.
Yes,
Lord,
Lordship,
is it-
I have challenged bill.
You have changed the rules, no?
Yes.
Okay, what is the rules?
Rules, my lord, is the medical admission rules,
Medical
my lord,
college.
2025.
Medical college and medical colleges.
Lord, so we'll
and
say
dental
page
colleges.
46. Page 46. There is a medical college and dental college of Assam regulation of admission into first year MBBS and BDS course. Amended rules 2025.
Medical College and Dental College of Assam, regulation of admission, first year MBBS, BGS course. Amendment rules 2024, is it? This is the one.
Yes, Your Lordship.
Please write down, since the provisions of Assam, since the provision of medical colleges and dental colleges of Assam, open bracket, regulations of admission into first year MBBS or BDS courses, close bracket, open bracket again, amendment, close bracket, rules, 2024 has been challenged. Registry shall list the matter before the appropriate bench.
Obliged.
Obliged, Your Lordship.
14th,
As pursuant to the liberty granted by your lordship, we are filing afresh. This is that matter which was argued, my lord. The lordship will find the impugned order at page 39.
Yes.
Right. Whereas on receipt of the report from various quarters regarding suspected leakage of question papers of the subject mathematics of higher secondary examination 2025, the examination of which subject was scheduled on 21st March 25 afternoon was cancelled by notification dated 23/25, whereas all the inspectors of school and principal of lead colleges were advised to take back all the seed packets, cartons of the question papers of subject mathematics from all the institutions immediately, that is on 23/2025 itself, by letter dated 23/25. Whereas the information and documents have been received from the concerned inspector of school and principal of lead colleges that below mentioned private institutions had broken the seal of the packets of the question papers of the subject mathematics before the scheduled date and time of examination. This act of the institution is in clear violation of the standard procedure. The petitioner college, Your Lordship will find in serial number 4, the first college NCD Senior Secondary School. Whereas all concerned inspectors of the school have been advised by the board to lodge FIR against the above mentioned institutions immediately to take legal action. Whereas pending receipt of outcome of police investigation, the affiliation permission of the above mentioned institution is hereby suspended with immediate effect. During suspension period, the institution shall not be allowed to take admission of students in class 11 for the academic session 2025-26. However, students studying in class 11 and appearing in HS first year examination will continue to study in the above mentioned suspended institution. So, my lord, without any notice, this order has been passed by which the institution has been placed under suspension. And during the suspension period, the affiliation and permission of the above institutions have been kept in abeyance, my lords, and fresh admission in class 11 have been disallowed. This is an institution which started in 2005. The government concurrence was given in 2010. Temporary recognition was granted in 2012. That Your Lordship will find at page 25. 6/9/2012. As per recommendation of the recognition committee, meeting held on so-and-so and subsequent approval of the council in its meeting dated so-and-so, the following institutions are hereby granted temporary recognition in the stream which subject is noted against each initially for 2 years with effect from academic session 2012-13. And if Your Lordship just turns the page at 26, serial number 9 is the petitioner school. Thereafter, my lord, it became a full-fledged examination center in 2013. That Your Lordship will find at page 28. There has been no allegation prior to this incident. Now, my lord, the question which I was, my lord's canvassing was whether there is an express provision authorizing the concerned authorities to place an institution under suspension in the applicable act and rules. And secondly, even if it is so available, would it be permissible for them to straight away pass such orders without giving some form of natural justice to the concerned institution? The act, my lords, the new act, my lords, the Lordship will find at page 53. And the relevant provisions, which are similar to the old act, my lord, that Your Lordship will find at 59/17.
2024 Act.
My lord, this is at page 53. At 59, if Your Lordship just have a look. powers and duties of the board, section 17.
Yes.
Subject to the provisions of this act, the powers and duties of the board shall be as follows, namely, your lordship may just have a look at 10 and 11. To recognize schools from classes 6 to 12 and to withdraw such recognition. To take such disciplinary action as it thinks fit against the institution as may be prescribed. Prescription is in the regulation. So 10 provides for recognition and withdrawal, does not provide for suspension. 11 provides for such disciplinary action as it thinks fit against the institution as may be prescribed. Your lordship may now have a look at section 30H at page 63. This is the enabling power. My lord has 63.
63.
Section 30 at page 63.
This is a part of the
Part of the act, my lord.
section.
30, my lord.
30.
30H is really we are concerned with. The board may, subject to the approval of the government, make regulation for the purpose of carrying out the provisions of this act, in particular and without prejudice to the generality of the foregoing powers. The board may make regulation providing for all or any of the following matters, namely, and H is, my lord, is what we are concerned with, disciplinary measures for malpractices in examination. So the regulation is an enabling power. Regulations can be framed providing for disciplinary measures for malpractices in examination.
Has it been framed?
My lord, that has been framed, my lord. I'm placing only the relevant part.
Yes.
Okay, Chapter 4, my lord, is pertaining to page 65, lordship has done.
Yes.
And at, my lord, 1168, withdrawal of recognition affiliation. My lord has that.
Yes.
The privilege of recognition may be withdrawn or withheld. Now, my lord, the issue that will arise
Withheld.
with her expression withheld encompasses suspension. It may very well be, but that's the gray area that calls for your lordship's consideration. Or withheld for any period from any institution by the authority competent to recognize that institution. If it has poor performance, less than so and so, it has willfully transgressed or evaded the rules in this chapter, or does not give reasonable good instruction, or does not maintain good discipline, fails to abide by the rules and regulations prescribed by the board or departmental of school education or director of secondary education. Well, these conditions will be fulfilled, because if the allegation is found to be correct, then I am violating the rules and regulation. But the issue that will arise is whether, because withdrawn or withheld, obviously this is not withdrawal, it is suspension. It is keeping in abeyance. Whether withheld can be read to mean suspension is an issue that calls for your lordship's consideration. Now, for the moment, I'm taking it against myself that it may, your lordship may very well hold, reading the act disciplinary measure with the regulation, that the concerned authorities, it may be encompass these rules and regulation, empowers them to place an institution under suspension if your lordship holds that withheld means suspension. The second question that would arise is, can they do it without adhering to the principle of natural justice? Whether it is a purely administrative order or it has an element of quasi-judicial decision-making that would require adherence to principles of natural justice. My lord, this is the short issue, my lord. We are alleging discrimination in treatment, but that, my lords, would call for records, etc. Now, may I please two judgment? One on suspension and on quasi-judicial decision making. First on suspension. Photo. 1917. Could you please begin? Hello, first, may I place 1970, 1 SCC 362. This deals with suspension, and your lordship may straight away come to paragraph 6. And this is really employer and employee issue. Paragraph 6, my lords. 3 kinds of suspensions are known to law. A public servant may be suspended as a mode of punishment, or he may be suspended during the pendency of an inquiry against him if the order appointing him or statutory provisions governing his service provide for such suspension. Lastly, he may merely be forbidden from discharging his duties during the pendency of an inquiry against him, which act is also called suspension. The right to suspend as a measure of punishment, as well as the right to suspend the contract of service during pendency of an inquiry, are both regulated by contract of employment or the provisions regulating the conditions of service. But the last category of suspensions referred to earlier is the right of the master to forbid his servant from doing the work which he had to do under the terms of contract of service or the provisions governing his conditions of service at the same time, keeping in force the master's obligation under the contract. In other words, the master may ask his servant to refrain from rendering his service, but he must fulfill his part of the contract. The legal position as regard the master's right to place servants under suspension is now well settled by the decisions of this court in Management of Hotel Imperial New Delhi versus so-and-so. The question whether a master could suspend his servant during the pendency of an inquiry came for consideration before this court. Therein, this court observed that it was well settled that under the ordinary law of master and servant, the power to suspend the servant without pay could not be implied as a term of ordinary contract of service between the master and the servant, but must arise either from an express terms in the contract itself or a statutory provision governing such contract. It was further observed therein that ordinary in the absence of such power, in express terms in the contract or under the rules framed under some statute would mean the master would have no power to suspend the workman, and even if he does so in the sense that he forbids the employee to work, he will have to pay the wages during the so-called period of suspension. Where, however, there's a power to suspend, either in the contract of employment or in the statute or rules framed thereunder, the suspension has the effect of temporarily suspending the relationship of master and servant, with consequences that the servant is not bound to render service and the master is not bound to pay. The same view was reiterated by this court in P. Kaji versus so-and-so. The rule laid down in the above decisions are followed by this court in R.P. Kapoor versus so-and-so. The law on the subject was exhaustively reviewed in so-and-so. Therein, the legal position was stated thus. The general principle is that an employer can suspend an employee of his pending an inquiry into the misconduct, and the only question that can arise in such a suspension will relate to the payment of wages during the period of such suspension. It is now well settled that the power to suspend in the sense of a right to forbid an employee to work is not an implied term in an ordinary contract between master and servant, and such power can only be the creature either of the statute or statute governing the contract or an express term in the contract itself. Ordinary, therefore, in the absence of such power, either in the express term in the contract or rules framed under some statute would mean that the employer would have no power to suspend an employee of his, and even if he does so in the sense that he forbids the employee to work, he will have to pay employees' wages during the period of suspension. Where, however, there is a power to suspend either in the contract of employment or in the statutes and rules framed thereunder, the order of suspension has the effect of temporarily suspending the relationship of master and servant, with the consequence the servant is not bound to render service and the master is not bound to pay. It is equally well settled that an order of interim suspension can be passed against an employee when inquiry is pending into his conduct, even though there is no such terms in the contract or in the rules. But in such a case, the employer would be entitled to his remuneration for the period of suspension if there is no statute or rule under which it could be withheld. The distinction between suspending the contract of service of a servant and suspending him from performing the duties of his office on the basis of the contract is important. The suspension in the latter case is an always implied term in every contract. Where an employee is suspended in this sense, it means that the employer merely issues a direction to him that he should not do the service required of him during the particular period. In other words, the employer is regarded as issuing an order to the employee, which would become contract suspension, the employee would obey. Man, this is the law on suspension. Normally, it is the terms of the contract or the service rules and regulation that must empower the employer to place him as suspended. But there is an implied power in the sense that to forbid him to do work, but in that period, the employer is obliged to pay full remuneration. This is on suspension, my lord. Generally speaking, the power must be provided in the statute. Here, my lord, if your lordship holds withheld encompasses suspension, then they have the power. That is a matter for consideration. Now, even if I'm assuming that the power is available, then can they do it without providing an opportunity, at least an explanation on the same day when the advice is made to the authorities to lodge an FIR, you're placing the institution under suspension. Affiliation is placed under suspension. Fresh admission in class 11 is disallowed. And all this in a class 11 examination without any complaint of the past institution of repute in a remote area. Now on quasi-judicial, my lords, because decision making, may I please 1962 SCC online, your lordship has that?
Yes.
This is cancellation of results, but the law is also, my lords, para 7 onwards, my lords. The first question, therefore, which falls for consideration is whether the duties cast on the committee under the Act and the regulation to act judicially, and therefore it is a quasi-judicial body. What constitutes a quasi-judicial body was discussed in Province of Bombay versus so-and-so. The principles have been summarized by Das J in these words. The principle as I apprehend them are: if a statute empowers an authority, not being a court in the ordinary sense, to decide dispute arising out of a claim made by one party under the statute, which claim is opposed by another party, and to determine the respective rights of the contesting parties which are opposed to each other, there is a list, prima facie, and in the absence of anything in the statute to the contrary, it is the duty of the authority to act judicially, and decision of the authority is quasi-judicial act. And if a statutory authority has power to do any act, which we are really concerned with two, my lords. If a statutory authority has the power to do any act which will prejudicially affect the subject, then although there are not two parties apart from the authorities, and the contest is between the authority proposing to do an act and the subject opposing it, the final decision of the authority will yet be a quasi-judicial act, provided the authority is required by the statute to act judicially. In other words, while the presence of two parties besides the deciding authority will prima facie, in the absence of any other factor, impose upon the authority the duty to act judicially, the absence of two parties is not decisive in taking the act of the authority out of the category of quasi-judicial act, if the authority is nevertheless required by the statute to act judicially. These principles have been acted upon by this court in later cases. So and so, my lords. Now, it may be mentioned that the statute is not likely to provide in so many words that the authority passing the order is required to act judicially, and that can only be inferred from the express provision of the statutes in the first instance in each case. And no one particular circumstances alone will be determinative of the question whether the authority set up by the statute has the duty to act judicially or not. The inference whether the authority acting under the statute, where it is silent, has a duty to act judicially, will depend upon the express provision of the statute, read along with the nature of right affected, the manner of disposal provided, the objective criteria, if any, to be adopted, the effect of the decision on the person affected, and other indicia afforded by the statute. A duty to act judicially may arise in widely different circumstances, while it will be impossible and indeed inadvisable to attempt to define exhaustively. My lords, may come, if your lordship turns the page. Somewhere in the middle, my lord. But we are of the opinion, my lord has that. But we are of the opinion in the
Paragraph 9.
my lord, it is continuation of paragraph. No, my lord, paragraph 10, my lord. 10, the lordship in the next page. In the middle of the paragraph. But we are of the opinion, the mere fact. Pagination may need.
Paragraph 10.
My lords, the paragraph 10, not in the first part of para, the following, the next page, my lord.
Oh, the next page.
Next page, my lord. In the middle, my lord. This is pertaining to the case in hand, in that case, but it gives an idea. Somewhere in the middle, my lord, but we are of the opinion.
What is the page number? Page 5.
Page 4.
It's written on the top, page 5.
My page. Okay. My lord, it is a Econ-P page. What is going to this? Minus the foot of page 4, foot of page 4.
Yes, but we are of the opinion.
We are of the opinion.
The second last line.
My lord. The mere fact that the Act and regulation do not make it obligatory on the committee to call for explanation to hear the examinee is not conclusive on the question whether the committee acts as a quasi-judicial body in exercise of its power under Rule so and so. Even though calling for an explanation and hearing the examinee may not have been made expressly obligatory by the Act and regulation, it is obvious the committee, when it proceeds to decide matters covered by Rule so and so, it will have to depend upon materials placed before it in coming to its decision. Where the committee decides to award any penalty, it has to come to an objective determination on certain facts. It is only when it comes to the conclusion on those facts are established that it can proceed to punish an examining concern. My lord, sir. This is if the concerned authority is required to take an objective view based on the materials placed before it, then it calls for an explanation is what has been indicated, and that is made clear, my lords, in the following para 11. Para 11 at page 6, my lord. My lord, the last line of para 5, page 5. It seems to us. My lord, I have page 5, last line. It seems to us, the lordship has that.
Yes.
It seems to us that the committee must be held to act judicially in circumstances these, though there is nothing expressed one way or the other in the act and regulation casting a duty on the committee to act judicially, the manner of disposal as it must be on materials placed before it and the serious effect of the decision of the committee on the examinee concern must lead to the conclusion that a duty is cast on the committee to act judicially in this manner, particularly as it has to decide objectively certain facts which may seriously affect the rights and careers of examinee before it can take any action under so and so. Here also, my lords, they are relying upon one-sided material placed before them. Before taking any action that seriously impairs the reputation and right of an institution, the minimum adherence to natural justice require that they should have called for an explanation, provided an opportunity of hearing before taking such drastic measures. Well, sum and substance, well, this is the two issues that arises for your lordship's consideration. One is whether withheld encompasses suspension. Assuming it does, whether it is a quasi-judicial decision which required adherence to principles of natural justice. It's not a pure administrative decision. It is based on material placed before the authority concerned. It has effect of impairing the good reputation without any antecedent of a called institution. It seriously prejudiced them. They can't take fresh admission. Therefore, a minimum, my lords, they should be material based on materials. So before taking an objective view of the matter, the other side should have been provided an opportunity. My lord, the admission process, as I understand, my lord, so far as compartmental student is going on. So there is still time. The people are willing to, my lord, this is a remote theory. The students are willing to. So if your lordship so considers, subject to outcome. Today, it's order of March. We don't know what is the outcome of police investigation. We are end of June. This today, balance of equities, I humbly pray, my lord, that admission process, if anybody is desirous, knowing the facts of joining the institution in class 11, it would be subject to the final outcome is what I am praying, my lord. So
What is the curriculum?
This is, my lord, class 11 will be class 2, my lord. It's a fresh, the existing students.
No, I mean, what I meant to say is that admission time starts from which
My lord,
point of time, up till which?
the students who have cleared the compartmental exam, their admission process is going on. The admission schedule, my lord, the fresh new session will start sometime in end of July, August. My learned friend would be in a better position, but it has not started. So there is time for the admission process so far as compartmental students are going on. The session has not begun. That will begin in end of July, August.
Compartmental means those
Who took the exam in the last examination, they fail in 1-2 papers. So their results come little later.
in class 11.
My lord. Portal is made inactive. If your lordship sees the last page of the writ petition.
Writ petition.
Of the writ petition, my lord. Page 73. NCD Senior College in the these are made inactive. So because of that, even if a student is desirous,
This is from the board.
but this is by the concern, my lord, the
By the
respondent
board.
board. They are not allowing, because of this order, obviously they can't allow, my lord. The order, if your lordship sees at 39, does two things. One, it places the recognition and affiliation under suspension. And during the period of suspension, I am disallowed from taking fresh students in class 11. So far as the existing student who had appeared in the mathematics examination in class 11, because this is the leakage is concerned, a class 11 examination. That examination is not a board examination. Those students have been allowed to be promoted to class 12. They don't suffer. It is the institution which suffers because they are now debarred from taking fresh students to class 11.
This affiliation permission, this is an annual affair, or once affiliation is there, it goes on?
So first, there is permission to start is given. That was given in 2006 under the old, because this was under the 84 Act.
Does it have a term? Affiliation for a certain period of time?
It might not be from 2012-13, temporary recognition is going on. There has been no problem.
Now, does it require renewal and all that? Periodical renewals?
That would be
Or once you are recognized or affiliated, it goes on?
that recognition is there because class 11 will go on. They are not taking the whole thing. Your lordship will appreciate the existing students is not affected. It is the fresh admission, because if your lordship sees at 39, but for this incident, there would have been no problem. 2001 government permission came about in 2006. That is the board's permission, the Higher Secondary Council. Government concurrence came in 2010.
No, that's okay. What I meant was that once the recognition is there, permission is there, it remains as it.
My lord, I am not a permanent.
And unless it's suspended, unless it's withdrawn or withheld, the recognition goes on, affiliation.
But the statute regulation only empowers them to recognize or withdraw or withhold. Suspension is not expressly used. It's not a terminology used in the act or the statute. Therefore, your lordship will have to consider what is the ambit of the word withheld.
Yes, that's it.
That is deeply obliged, my lord.
That's okay.
Well, first of all, my lord, I am 2 points, my lord. Two issue is there, my lord. One is, my lord, they are saying that in the statute, act and regulation, there is no specific provision for suspension. And another is, my lord, there is a violation of principal naturality. Two issue. Am I right? Two issue only. So, my lord, lordship kindly see page 39. The existing class 11, those who are reading, and 12, they are not, they are protected. They are allowed to go on. Only it is pure temporary suspension. It is suspension that order can be passed by the secretary. Secretary has a power in the regulation. I will show it, my lord. Regulation there. So it is not a case that secretary has no power to pass such order. Yes, relevant portion, my lord. Yes, yet today. 3, but duties and responsibility of the secretaries of the division of the board. Also called C, A, B, C clause. Secretary shall do the official correspondence on behalf of the concerned division of the board and shall issue necessary orders, oblique notifications, oblique circulars, etc., relating to defined aspects of the affairs of the concerned division of the board. This is expressly given power to the secretary to pass any order. This is a suspension order passed by the secretary that has been given by the power, the regulation. Regulation itself, but they are not challenging the act or regulation, either one or both. They are not, there is no express provision, so and so, secretary has no power. This I have perused all these things, my lord. Regulation secretary duty is to see shall do official correspondence on behalf of the concerned division of the board and shall issue necessary orders, notification circulars. So what wrongs, my lord? The suspension order, why suspension order is there, my lord? The immediate measure, because they have received report that exact mathematics into examination 2025 paper has been, my lord, offended. So it is very serious offense, my lord, in academic matters. We are dealing with the academic matter, my lord. While dealing with the academic matter, Supreme Court says court always reluctant to pass order hesitantly and always slow. I will go through it as case law, my lord. Now, according to power of the board, secretary is concerned to pass this impugned order, my lord. He has power. And secondly, my lord, the violation of principle and natural justice. There is no question of violation of principle and natural justice, because when a person is suspended in a service matter also, there is not duty of the operating authority to ask him, Mr. B, I will suspend you or not. This is another question. There is no question. After suspending an employee, the authority will, my lord, thereafter they will issue notice if departmental proceeding is started. This is not a case of departmental proceeding. This impugned order has been passed, keeping the sanctity of the examinations. That is a very heinous kind in the education matter, my lord. Academic matter is very serious. Lordship will take up to 2 p.m. or continue, my lord.
I think we should finish this.
Finish. Yes.
If it's okay with you all.
Yes. I also would like to. Yes. So the violation of case law. So one is case law, my lord, 2007-8 SCC. Here says, my lord, a ratio recently. Punishment, natural justice, personal hearing is not necessary in regard to inflicting minor penalties. Even though when minor penalty is inflicted, personal hearing or so-called notice is not necessary. Here is not a punishment, my lord. This suspension is not a punishment. It is only a, my lord, temporary measure to suspending the institution to admit new candidates, new students. That is class 11. That is the only. And the existing students, they are reading, they are protected by this order. They are not disturbed.
Okay, which is the ruling which you are?
Also, can you see the case law? Oh, yes. 2007, my lord, also can you see? State of Punjab versus Nirbhar Singh.
Yes.
Ratio recently is punishment, natural justice, personal hearing is not necessary regard to the inflicting minor penalty. The paragraph 4, lordship can see. The competent authority appointed S.B. Gupta and then superintendent engineer as inquiry officer. The inquiry officer submitted a report exonerating the respondent of the charges leveled against him. The competent authority disagreed with the findings of the inquiry officer, and a notice was issued to the respondent along with a copy of the inquiry report and dissenting note. The respondent filed a reply to the so-called notice by letter dated 21 January 2000. The reply was rejected by the affording respondent an opportunity of personal hearing. Thereafter, the disciplinary authority, with the concurrence of the Punjab and Public Commission, awarded punishment stoppage of 2 annual increments with cumulative effect by the order dated 28 October 2003. Agreed thereby, the respondent filed a review appeal before the authority on demand. The essayed review appeal prepared by the respondent was considered by the competent authority, and the same was rejected. And by order dated 2004, agreed today, he prepared a petition before this High Court. This Lordship Callisis, paragraph 6. Rule 21 of the Punjab Civil Service Punishment and Appeal Rules 1970 deals with the review. A perusal of the aforesaid rule shows that there is no provision of personal hearing in regard to inflicting minor penalties. The rule contemplates a personal hearing only when the disciplinary authority proposes to impose any of the major penalties specified in clause so-and-so of Rule 5 and to enhance the penalty imposed by the order sought to be reviewed to the penalties specified to clauses. Admittedly, by the order dated 28 October 2003, the respondent was inflicted punishment of stoppage of 2 increments with cumulative effect, which is a minor punishment. The High Court, in our view, was clearly in error in setting aside the order dated 24/6/2004 passed by the competent authority on the ground of violation of principle and natural justice. So, in case of minor punishment, my lord, penalty, whatever may be the even minor punishment, it's a punishment. Impose, penalty impose. It is necessary, my lord, question of giving notice is not necessary. And personal hearing is not necessary. It will not. Next one. And so far is concerned, my lord, I don't want to one case is the ballot, Lordship kindly see regarding, yes, 184 to 4 SSC 2007, the Maharashtra State of Board of Secondary. Here, Lordship kindly see citation number 1984 4 SSC 27. Malad, paragraph state where I want to bring your lordship's
Name of the party?
Name of
Parties?
the party, Malad, Maharashtra State of Board Secondary, Higher Secondary Education versus Poetus Bhupesh.
Okay.
You
Yes.
got it, lordship?
Yes.
Paragraph 33.
Mm.
Yes, paragraph 33. Far from advancing public interest and fair play to the other candidates in the general, any such interpretation of the legal position would be wholly defensive of the same. It has been repeatedly pointed out by this court, that is Supreme Court, that the court should be extremely reluctant to substitute its own views as to what is wise, prudent, and proper in relation to academic matters in preference to those formulated by the professional men possessing technical expertise and rich experience of actual day-to-day working of the educational institutions, and the departments controlling them. Department controlling them, that means the board. It will be wholly wrong for the court to make a pedantic and purely idealistic approach to the problems of this nature, isolated from the actual realities and grassroots problems involved with the working of the system, and unmindful of the consequences which should emanate if a purely idealistic view as opposed to the pragmatic one were to be pronounced. It is propounded. It is equally important that courts should always, as far as possible, avoid any decision or interpretation of any statutory provision, rule or bylaw which should bring about the result of the rendering the system unworkable in practice. It is unfortunate that the principle has been adequately kept in mind of the High Court while deciding the instant case. In the light of the foregoing discussion, we hold that the High Court was erred in striking down the some clauses of the Act. These are the regarding the academic matter, my lord. So far, my lord, I am concerned, my lord. There is a provision, my lord, 2006. 2006 5 SCC 386. My lord, KP Sudhakaran and others versus State of Kerala.
Paragraph?
Has you got it, lordship?
Paragraph?
Paragraph, yes, I am going it. Paragraph 16, lordship, kindly see.
16.
The transfer LDC next has submitted to insurance provision that the person on an own request transfer will be ranked as to the journalist in the new district and new unit. It is ensured that the seniority of the existing employees at the category and the new unit or the district is not affected by a senior person coming from outside the transfer. It is contended that there, where the promotion post is state-wise, the seniority of the existing employee in the district in which the outside employee is transferred.
In the
Yes,
part
yes.
you want to read
Yes,
is
I'm going on what, sir.
once a statutory
Once that is this point, sir.
is made without
Yes.
adding any exceptions. This is the one.
It is a once a statutory rule is made without providing any exceptions, it is not possible to carve out exception to such rule by a judicial interpretation. That it means the regulation is there, power is there, and there is no exceptions when passing the order. That exception means provided that issuing such suspension order, secretary will have to, authority will have to issue a notice. That exception is not there. If there is no exception is there, So Lordship, by interpreting judicial interpretation, my lord, you cannot carve out an exception. For this purpose, this case is placing. And now, last is, my lord.
I've seen it, paragraph 14.
Yes, paragraph 14.
I think almost on the same point.
Yes, same point.
Court cannot take upon the task of statutory
Yes,
authorities.
Next, last was there? No. Who executed there?
So,
no, other cases, but yes, look at it. So, under two cases I will place. This is a, my lord, what is, I actually, before issuing notice, I will say something, my lord.
yes.
Because it's the third time I will have to say to them, my lord. I'm
Yes.
sorry to say, my lord, I will have to say.
Yes.
First of all, no interim order can be passed by the honorable motion stage where the main paragraph and interim paragraph is same. For this purpose, my lord, it will be there. Yes, Lord, you can see. Two cases, my lord. That is my last submission, my lord. One is, my lord.
Interim order should not overreach the main prayer.
Yes, in the motion state, is the main prayer and interim order is the same. That cannot be, my lord, pass because it amounted to allow the writ petition in the motion stage. Lordship, kindly see paragraph 3, last we. 1, 2, 3, 5, 4. We have heard so learning appearing for the state of Assam, senior counsel appearing on behalf of the respondents, having heard the learned senior counsel for the parties and after considering the impugned order as well as nature of relief claim in the writ petition by the respondent, we are of the view that High Court had fallen in grave error in staying the order of termination during the pendency of the writ petition. In our view, the interim order granted by the High Court staying the order of termination could not be passed at this stage in view of the fact that if such relief is granted at this stage, the writ petition shall stand automatically allowed without permitting the parties to place their respective cases at the time of final hearing of the writ petition. In this case, also the appellants have not yet filed counter affidavit to writ petition the respondents. And next case is, my lord, State of Haryana versus Suman Datta, 2000.
Yes, I got it.
Oh, you got it. Also, kindly see, small order, my lord, leave granted. This appeal by the state Haryana is directed against an interim order passed by the High Court of Punjab and Haryana at Chandigarh in so-and-so, staying the order of termination. The positive case of the state is that respondent did not pass the necessary examination in shorthand and typing. We are not expressing any opinion as to whether the services of the employee could be terminated for not passing the shorthand or typewriting test, but we are clearly the opinion that High Court erred in law in staying the order of termination as an interim measure in the pending writ petition. By such interim order, if an employee is allowed to continue in service and then ultimately the writ petition is dismissed, then it would tantamount to obstruction of the public office without any right to the same. We therefore set aside the impugned order of High Court staying the order of termination. So, my lord, my humble submission before Lordship, my lord, as this states, my lord, notice, I cannot say the notice may be issued. Lordship, I'm sorry to point out on this thing. This matter is come from Dhamaji district. Lordship, Kalisi writ petition, they made the district as Kamrup Metro. It may not affect the merit of the case. It is true. But it is the High Court rules where Rule 3A says there is a judge in charge, Lordship, perhaps Lordship also judge in charge. Judge in charge of district. One or more district may be entrusted to one judge who is in charge. They will look into the matter, what is going on, what is not going on. So this district is essential. It is for shown as Kamrup. Then who is the judge in charge of the Kamrup district? So and so justice may be supposed. Then he will collect it from him. It is wrong. And another is, Lordship, page, Lordship, kindly see page 4. That's why the Assam School Education Board, Division 2, represented by Secretary Bamuli Moidam Guwahati 1. The Assam School Education Board, there is no type of Assam Education Board, madam. The Assam State School Education Board. Lordship, Act is there. They have got this Act. Lordship, kindly see the page 53. page 53, the act is there with them, even though they have mistake it, my lord. How can I accept the notice, my lord? My learned friend Goswami can direct them to my junior. I am not blaming the Goswami because he is senior, he is moving this best. But what they are doing, the junior, is apparently, Lordship calls this act 53, Assam State School Education Board Act 2024. So the secretary, the Assam School Education Board, Division 2, there is no this type of board. And next 3, the secretary of School Education Board, Division 2. Where is the state? Where is the state? And another is also I am showing Lordship why passing this order is difficult. The Lordship kindly see the para portion, Lordship. Kindly see, my lord, these type of blanket, my lord, mistake. Page 70, Lordship kindly see. This is the para. Para 1, to set aside or was the impugned order dated 22/3/2005 issued by Secretary Assam State School Education Dispute. What is this? I am thinking, how can I accept a notice, my lord? How Lordship will pass this order? Suppose Lordship going to pass an interim order. How Lordship will pass the order? How Lordship will issue a notice? Dispute, where dispute? Assam State School Education Dispute. There is no. And next also, my Lordship can see interim order. The interim, your Lordship may be pleased to state the impugned order dated so and so issued by the Secretary Assam State School Education Dispute. Again and again, they are doing the mistake. Lordship kindly say how Lordship will pass the order. It is a vexatious petition. I must submit that this should be thrown out and dismissed immediately. This type of, this is a third point I pointed out. The first one, that was the Chief Justice. Third was the expiry. That was the repeal act. Now they withdraw. Again, they have not learned the lesson, my lord. They have done this. I cannot accept it. And Lordship cannot, I think, cannot pass this order. How Lordship will direct it? Whom? Dispute.
All right. We'll come back at 2 and see what.
So, my lord, this is a vexatious petition, my lord. I don't like to place all these things, my lord.
This seems to be for me a vex thing.
No, I am not
And the
blaming Goswami.
minuteness of my learned friend, one has to admire. I was telling them, you ensure everything is compliant, he's there. But on the main point, there is undoubtedly issues arise for consideration. Not all those issues will have to be considered at the time of hearing.
We'll come.
Regards the notification, I quite see the difficulty. That notification of your Lordship's court regarding my learned friend, I am going to the Your Lordship has the power to, in case of amendment in the cause title is under the orders of the court, filing of amended cause list title will suffice. Otherwise, we are required to file. But I leave this entirely at your Lordship's hand. I'm embarrassed, but that is so.
What is to be done?
One, they pointed out page 2, secretary, one word is missing. Page kiman? 3, 4, my lord.
Respondent number 2.
Respondent number. State is missing. Assam State School. 1,
2 and 3. Correct.
My lords. State word is missing.
Then
at page 17.
again,
Education board is missing and it should have been Damuni Maidan instead of this board. Board is missing essentially and in the interim also.
you replace it and you replace it. We'll issue notice at this stage,
My lord,
but you'll replace it by Monday.
do it.
Mr. Bora, you should take
Fine.
due care.
Your Lord, I was telling them. Court's title I did not see.
This court is also very particular about these things, you see.
Lordship is right.
No, I'm sorry to say why I should mention in my lord, senior advocate is into awkward position, my lord, because they have done the wrong, my lord, juniors.
All right, heard Mr. P.K. Goswami, now senior counsel, assisted by Mr. B.P. Bora for the petitioner, who submits that the petitioner is agreed with the order dated 22/3/2025 insofar as the petitioner school is concerned. By which the affiliation of the school to the Assam State School Education Board,
Division 2,
Division 2,
Bamuni Moidam.
Bamuni Maidan has been
Was
suspended with immediate effect. And that the school has been prevented from taking any admission of students in class 11 for the academic session 2025-2026. Stop the learned senior counsel submits that prior to issuance of the impugn order, no opportunity was given to the petitioner for showing cause as to why such an order should not be passed. Stop. Secondly, the learned counsel submits that there is no provision under the Assam State School Education Board Regulations 2024 by which the school can be suspended. To stop all that, Chapter Roman 4 of the regulation at clause 11 provides is for withdrawal or withholding of recognition oblique affiliation of any institution for the reasons assigned under the said clause 11. 11 will be within bracket, okay? Stop the learned senior counsel submits that the petitioner school was given a temporary recognition for a period of 2 years with effect from the academic session 2012-2013. Invite order dated 6/9/2012. Stop thereafter by notification dated 23/10/2013. The school was recognized and upgraded as a full-fledged examination center for holding HS final examination 2014. So therefore, the petitioner school has been functioning without any blemish while abiding by the rules and regulations framed by the state government or the Assam State School Education Board.
I see.
The Learned Senior Counsel submits that the Tribune order dated 22/3/2025 has been passed only by considering one side of the story and without any opportunity to the petitioner school to explain itself. Stop. He therefore submits that pending final consideration of the writ petition, the Tribune order dated 22/3/2025 may be stayed. In support of his submission, the Learned Senior Counsel relies upon the following authorities. Number one, BP Gidronia versus State of Madhya Pradesh and another 1970 1 SEC 362, and number two, Board of High School and Intermediate Education UP Allahabad versus Ghanshyam Das Gupta and others 1962 supplementary 3 SCR 36. Next para, Mr. T.C. Chutia, Learned Additional Senior Government Advocate.
Standing Council, my lord.
Standing Counsel,
ASSEB, ASSEB.
ASSEB. Has strenuously argued on the maintainability of the writ petition and also has pointed out the mistake committed in the nomenclature of the rate parties, both in the cost title as well as in the prayer portion. He submits that the ASEB indeed has the power to issue an order of suspension in terms of regulation. In terms of Chapter 2, Part Roman 6, clause within bracket 2 and within bracket small c. Of the regulation of 2024. Now he further submits that there is no provision for giving a personal hearing prior to issuance of the suspension order, and therefore, in absence of which the petitioner cannot insist upon being given a chance. Stop the Learned Standing Counsel also submits that in absence of any provision provided by the regulations. An exception may be not be carved out by the court. Stop. As for the interim prayer sought by the petitioner, the learned standing counsel submits that same should not be given, as it would amount to allowing the writ petition itself. That means he therefore submits that the writ petition should not be entertained. In support of his submission, the learned standing counsel has relied upon the following authorities. Number one, State of Punjab versus Nirmal Singh, 2007, 8 SCC 108. Number two, HP Public Service Commission versus Mukesh Thakur and another. Two 2010 6 SCC 759. Next, KP Sudhakaran and others versus State of Kerala and others, 2006 5 SCC 386. Next, Maharashtra State Board of Secondary and Higher Secondary Education and others versus Paritosh Bhupesh Kumar Sheth and others, 1984 4 SCC 27. Next, State of UP and others versus Sandeep Kumar Balmiki and others, 2009 17 SCC 555. And State of Haryana versus Suman Datta, 2000 volume 10 SCC 311. Upon considering the rival submissions at this stage, this court is of the prima facie view that the projection made by the petitioner and the grievances made requires proper examination, and therefore let notice of motion be issued, returnable by 4 weeks. Who will accept notice? Government or
Ballot?
you'll?
Ballot? Government.
Ms. P. Das, learned standing counsel. B. Das. P. Das. P for Punjab, isn't it? Ms. P. Das, learned standing counsel, Secondary Education Department, accepts notice on behalf of responding members. 1,
4. 4.
1, 4, 5, and 6. Well, Mr. PC Shutiel, Annette, standing counsel. ASSEP
2, 3, and 7. Ballot.
accepts notice on behalf of responding numbers 2, 3,
and 7.
and 7.
Ballot subject to correction made by them. Ballot. Otherwise, I cannot accept it.
I'm going to give that a direction. There be a direction.
Ah.
I think that's complete. As such, notice upon the respondents are complete. Stop. However, as pointed out by Learned Standing Council, ASSEB, there is some mistake in the nomenclature of the said board, and for which the petitioner is permitted, and for which the petitioner shall file the corrected cost title as well as the prayer portion of the writ petition by Monday next date by 36/2025 in two sets, whereafter registry shall do the needful. The petitioner shall also furnish requisite copies of the corrected cost title to the learned counsels for the opposite parties within 3 working days. Next para, having regard to the projection made, this court is of the prima facie view that some protection requires to be given. And accordingly, the impugn order dated 22/3/2025, insofar as the suspension of the affiliation of the petitioner school and the prohibition for taking admission for class 11 for the academic session 2025-2026 is concerned shall remain suspended. Stop the same, however, will be subject to the outcome of the writ petition.
Deeply obliged, ma'am.
This is the matter again after 4 weeks. We'll give a date. 4 weeks. Okay.
Lordship, we are really sorry for that.
No, I joined in, my lord.
Be careful.
No, Your Lordship,
Like
this-
sometimes you get excited also. You see, suddenly a fresh case comes and you do that. But
No,
make sure that you cross check. It's very required.
Our credibility depends.
Mr.
on-
Shutia has rightly pointed out.
He has the right to do so.
He's rightly pointed out because these things are very, like required to
Deeply
be careful.
obliged.
Yes.
Deeply
Obliged.
15, Item 15. Yes.
May I please, Lordship?
Yes.
That the petitioners are the grade 4 employees of Varpara Polytechnic College and Golpara Polytechnic College, Lordship. They were appointed in the year 2017, Lordship, when the government of Assam established 11 polytechnics and 2 engineering colleges, Lordship. Initially, the government has provided the companies, Lordship, to appoint the grade 4 employees of this polytechnic college, Lordship. Thereafter, after 3 years of this service provider, Lordship, they expressed their inability to continue the service, Lordship. Then the government took this petitioners, Lordship. Lordship, kindly come to the page 17, Lordship.
What are the petitioners?
Page 17, Lordship.
What are the petitioners?
Petition number 1 is the serving in government Barbata Polytechnic, Lordship. 2 petitioners is
Yes, what are they doing?
grade 4 employees, Lordship.
Grade 4 employee, both of
Yes.
them. Both in the same institution.
No, Lordship. Petition number 1 is the Barbata Polytechnic, Lordship. And petition number 2 is the Golpara Polytechnic, Lordship.
Okay. So what is the grievance?
They are agreed by the office memorandum dated 13/9/2024, Lordship.
Page number?
Page 25, Lordship, Annexure 4.
Yes, what does it
Page
say?
25. In the said office memorandum, Lordship, can you see para 1, Lordship? bottom line, Lordship. The governing body of the engineering colleges public polytechnic will be authorized to engage maximum 17 grade 4 staff on temporary basis. Therefore, Lordship, para 2, Lordship, the temporary engaged grade 4 staff must be born in Assam and be from respective district where the institution is located, having initial education in the state. 2,
Yes.
discipline and medically fit, physically fit enough to carry out the specific job. 3, above 18 years and not more than 40 years of age, and minimum class 8 pass. Here the petitioners, they are overage, Lordship. They are above 40 years. Lordship.
You're working as what? Temporary basis?
Temporary basis here, and now again they publish this office memorandum. So in the place of the petitioner, they want to engage another the newly Lordship grade 4 employee, Lordship. So being agreed, Lordship, the petitioner filed this petition. Similar other grade 4 employees also filed this petition, Lordship. This one about also pass an order, Lordship. Kindly come page 40, Lordship.
40.
Page 40, Lordship. And operative part, Lordship. Yes, so operative part is, Lordship, page 46, Lordship.
Yes.
Having regard, Parathean, Lordship, having regard to the projections made on behalf of the petitioners and considering the fact that petitioners are currently engaged in this is the Nalbari Polytechnic, Lordship institute since about 7 years continuously. The responding authorities shall not replace the petitioner by taking result of the office memorandum dated 13/9/2024. There is till 8/1/2025. Therefore, Lordship, it has continued into order, Lordship. I have also the copies of this honorable court order, Lordship. So, Lordship, limited prayer, Lordship, these petitioners may be protected, Lordship, because they are appealing, Lordship, anytime they may be removed, Lordship, by passing a notice, Lordship.
Still comment?
Yes, Lordship, similar order may be passed, Lordship, and the similar repetitions were.
That will go, but what will be the ultimate fate? What will happen?
Lordship,
Have you replied to the
other repetitions?
other
Lordship?
petitions?
Yes, Lordship, we have replied, and those repetitions were fixed on 29th of July, Lordship, for final disposal. So this may come along with that, Lordship.
Okay.
And in this matter also will file a affidavit, Lordship, by then.
But Mr. N.H. Laskar,
NH Laskar.
Learned Counsel for the petitioners, who submits that the petitioners are grade 4 employees working under the which polytechnic?
Petitioner number 1 is Borpeta Polytechnic, Lordship.
Under Borpeta and
And petition number 2 is Golpara Polytechnic.
Golpara Polytechnic. And they are aggrieved with the office memorandum dated 13/9/2024, bracket annexes 5, by which amongst the various criteria fixed for being employed as grade 4 employee, the minimum age has been fixed as 18 years and the maximum age as 40 years. Full stop. The Learned Counsel submits that the petitioners by now are over age and the office memorandum has deprived them the opportunity of being a regular employee. Stop. The Learned Counsel submits that a number of cases have been filed challenging the office memorandum, and one such case is WPC number 6972 of 2024, bracket annexure 7.
Another one is Lordship 7001.
It's okay.
Yes, sir.
Wherein this court, white order dated 20/12/2024, has directed the respondent authorities not to replace the petitioners therein by taking resort to the office memorandum. To stop, he submits that the interim order continues as on date and civil protection may be given to the present petitioners. Next, para in view of above, issue notice of motion returnable by 4 weeks. Mr. D. Upamanya, Learned Standing Counsel.
Higher Education
Higher
Department.
Education Department accepts
one and
notice
two.
on behalf of respondent numbers
One
one.
and two.
Who are the others?
Lordship, notice will have to go.
Others governing
Petitioner shall furnish requisite copies of the writ petition to Mr. D. Upamanya within 2 days. Stop petitioner shall take steps for service of notice upon the remaining respondents, that is respondent numbers 3 to 6 by registered post with ADU within 3 working days. Stop. Having regard to the projection made, it is provided here in the interim that the services of the petitioners shall not be replaced by resorting to the office memorandum dated 13/9/2024 till the next date of listing. This is the matter.
29/7
This is the matter again on 29/7/2025,
along with WPC Lordship.
along with WPC number
6972 of 24.
6972
Yes.
of 2024.
highly obliged.
Highly obliged.
16.
May I please, your lordship?
Yes.
My lordship, I am president of the school managing committee of Sonabari Jatiya Vidyalaya Bhutia Dinga. I have filed a representation on dated 5/4/2025 before the district commissioner South Salmara Mankachar, which is the next, my lordship. Page 38 may be seen, my lordship. Our contention is in the representation is that we are having all the necessary, we have fulfilled all the necessary requirements and running the school, my lordship. And the respondent number, private respondent number 10, without possessing any recognition, affiliation, anything, illegally started a school within the proximity of 400 meter of our school, which is entirely illegal as per the law, my lordship, as per the non-government education, which I have annexed page 26, my lordship. Notification, the Assam Non-Government Educational Institution Regulation and Management Amendment Act 2018, my lordship.
Who's the petitioner?
I am SMC president of my school, my lordship. School Managing Committee president, my lordship.
What is the name of your school?
My lordship, Sonabari Jatiya Vidyalaya Bhutia Dinga. UDICE code is 18320611608. So our only prayer is that our representation, the district commissioner may dispose of the representation and take necessary steps.
Mr. Kaushik, what do you say? Representation is pending.
He claims so, my lord. His basic allegation, my lord, comes that from his submission that this another school has been opened within a close proximity of 400, which otherwise is affecting his competitors.
Yes. Illegally, that school does not have recognition.
Illegally is an allegation, my lord. He has not placed on record anything. Clearly appears to be an adversary litigation. He is aggrieved because some other school has been opened within a close proximity of 400.
And
So-
thereby stealing all the students.
Yes, that is basic grievance.
For
my lord.
opening our school, my lordship.
Your
we have
students
to
will go
take-
there.
No, my lordship.
That's why you are
As
afraid.
per rule, my lordship, for opening our school, we have to take no objection certificate from the nearby school. I have next.
So let us issue notice and examine your case.
Yes, my lord.
Not simply saying representation is disposed. Okay.
Yes, my lord.
But
He's
Mr.
overburdening the authorities, man.
SB Lashkar.
He's asking for an inquiry from the authorities.
My lordship, on the last few months, my lordship, the government of Assam has taken action against various fake institutions.
Oh, you want to take
giving
instructions?
My lord.
Deputy Commissioner.
Even in Karimganj district, my lordship.
District Commissioner, South Salmara. You get instructions there. Mr. B. Diori, learned government advocate, shall obtain instructions as to what has transpired to the representation submitted by the petitioner before the District Commissioner, South Salmara, Mankachar, at Hatsing Mari on 5/4/2025, an extra 7, bracket. Petitioner to furnish extra copy of the writ petition to Mr. B. Diori for obtain the instructions. List again on so and so.
My lord, another instruction may be called for whether the state school has any recognition and affiliation. That thing also.
No, that we'll see. Let us see with the representative.
13-8. 17.
Highly obliged.
May I please, your lordship?
Yes.
Lordships, petition, there are two petitioners, my lord. The both were, my lord, appointed as subject teacher at Balazan HS School, my lord.
Mhm.
Petition number 1 against the political science, my lord, and petition number 2 against the advanced Assamese, my lord. And both, my lord, on 11/12/1997, they have joined the school, my lord. Thereafter, my lord, right, my lord, 27/5/2005, lordship may kindly come to page number 20, my lord.
What is your basis of your claim for provincialization?
Claim is, my lord, we are the senior most teachers of the school, my lord, and my names were forwarded with the list of the teachers, my lord. Thereafter, my lord, the district level, they have wrongly sent one of our petitioner's name against the wrong subject, and petition number 1's name has been dropped, my lord. That complaint was raised by the principal, my lord. But in the end, in the impugn order, my lord, both the petitioner's name were dropped. Without
Yes,
any reason.
yes, Mr. U. Sharma will know.
Notice may be issued.
Yeah.
Okay, heard Mr.
S. Doctor.
S. Datta, learned counsel for the petitioners,
Yes, sir.
who submits that by filing this petition, the petitioner seeks for a direction to the respondent authorities to consider the provincialization of their services with effect from 30/11/2021 against the subjects political science and advanced Assamese by rectifying the list of the provincialization order dated 30/11/2021. Next para, issue notice of motion returnable by 4 weeks. Mr. U. Sharma, learned standing counsel.
Secondary education.
Secondary education accepts notice on behalf of respondent members.
Respondent number?
All the respondents.
No, 1, 2, and 3.
Respondent numbers 2 and 3. While Mr. B. Dury, learned government advocate, accepts notice on behalf of respondent number 4.
Extra copies may be furnished.
Yes.
I think 1 also you should appear.
He is already 1, 2, and 3 million.
Yes.
1, 2, and 3.
1, 2, and 3.
Services therefore complete. Petitioner shall furnish requisite copies of the writ petition to the learned counsels appearing for the respondents today, within 2 days. List again after 4 weeks.
I love less. Pendency may not be bar, my lord.
Any hope?
Yes, sir. Yeah, because the application is still pending, my lord.
Okay, pendency of the writ petition shall not be a bar for the respondents to mitigate the claim of the petitioners.
I love less.
Item 19.
May please, your lordship.
Yes.
Lordship, there is a content petition. Lordship may find the order at page number 28.
What are you challenging here?
Lordship, this is for.
Contempt.
Yes, Lordship. Contempt.
Where's the order?
Page number 28, the effective part, Lordship.
Order passed in the IA.
Lordship, that is a correction. In the IA, that is a correction. It was passed in the WPC number 6585 of 2013. The order starts at page number 13, Lordship.
Page number?
13.
40.
13. Starts at 13 and the effective part is at Lordship 28.
28. What was the order?
It is that in view of the said decision of the coordinate bench of this court in Purnima Hore, the petitioners upon clearing the JPT and upon being authorized a scale of pay will be entitled to count the stipendiary period of services rendered by them as qualifying service for the purpose of computation of pension. And Lordship, after that.
Okay, just a minute. This order was passed in the 2023.
Yes, Lordship.
Now, we are in 2025.
In 2024, Lordship.
What is that IA for?
That is for correction of certain portions of that WPC.
So that has given you a fresh life.
Yes, Lordship.
Which is the operative portion?
Page number 35, Lordship.
36. 36. Then when did you file your contempt?
June 13th, Lordship. Lordship, the representation is on 25/6.
Oh, thing is that are you not barred by limitation?
Lordship, the representation is from 25/6. They has to consider it from the day of the representation.
Okay, heard Miss.
And Begum, Lordship.
Sorry?
And Begum.
N. Begum, learned counsel for the petitioner who submits that. This contempt petition is filed for willful violation of the court's direction dated 15/12/2023. Passed in WPC number 6585 of 2013. And also the order dated 3/6/2024. Passed in IA C number
1440.
1440 of 2024. Despite a copy of the orders having been furnished to the respondents concerned. Next expiration notice returnable by 4 weeks. Petitioner to take steps for service of notice upon the respondents. How many respondents are there? Oh, one. One respondent.
Yes, sir.
Respondent by registered post with AD due within 3 working days. List the matter again after 4 weeks.
Much obliged.
21.
May it please the Lordship. Matter relates to compassionate appointment, Lordship. Third round of litigation, Lordship. First case, petitioner approached before this honorable court. This honorable court directed the authority to place the case of the petitioner before the DLC, Lordship. Accordingly, it was placed. But the case of the petitioner was rejected on the ground that
Why are you here again?
Lordship, DLC recommended, Lordship. Now DLC recommended
When?
Page 36, Lordship. Relevant page.
And
Serial number 7.
serial number 7.
Yes.
What is your name?
Baharul Islam Chaudhary.
What is the remarks? Assistant teacher.
Yes, Lordship.
DLC minutes is dated.
And 19/9/2023, Lordship. Page 34, Lordship. Top.
So it has to go to the SLC.
Yes, Lordship.
It has not gone.
No.
Yes. Mr. Diori.
So, let it be in the next SLC.
Okay. But Mr.
And Hussain.
N. Hussain, learned counsel for the petitioner who submits that this is the third time the petition is before this court seeking consideration of his case for compassionate appointment. To stop, the learned counsel submits that the state level committee the district level committee Hailakandi in its meeting dated 19/9/2023
Yes.
considered and recommended the case of the petitioner for
Assistant.
appointment to the post of assistant teacher, LP school. But however, the case of the petitioner has not been considered by the state level committee, SLC, till date. And therefore, petition is before this court. Next para, it is stated at the bar that the state government on 18/9/2024 had come up with an office memorandum by which compassionate appointment has been stopped in view of the introduction of compassionate family pension scheme. Stop. Agreed with the same, a number of writ petitions were filed before this court, and they were all disposed of by a common order dated
3/4/2025.
3/4/2025, and the lead case being WPC number 342 of 2025. This court, while disposing of the writ petitions, directed that all the pending cases should be considered by the state government as per the existing policy for compassionate appointment. Full stop. It is seen that the present case is also squarely covered by the state direction, and accordingly, writ petition is disposed of with a direction to the
Respondent number 4.
Secretary to the Government of Assam, Department of School Education, bracket respondent number 4, to place the case of the petitioner before the next SLC for consideration in terms of the recommendation made by the DLC on 19/9/2023. Did I say dispose? Okay. All right.
Obliged, nothing.
My lord, item 23, my lord, this is the same matter my lord, that they came up before lordship, mathematics matter, my lord, and his interview is on 4th, my lord. So, my lord, similar order may be first, my lord, item 23, my lord. Otherwise, my lord, vacation is there, my lord.
What is that matter? I don't
That
remember.
matter, my lord, my lord, prescription was made by an addendum in a SOP, my lord.
See, we'll do one thing, we'll post it on Monday. I have to rise. Monday. Monday is I think it's a vacation bench is there.
Vacation benches.
Your Lordship, that secondary educations, Your Lordship, Nijukti Moina Asoni, that scheme, Your Lordship, that continuously coming, Your Lordship, in motion column. Here, another, in supply list, supply motion has listed, Your Lordship.
Which are they? Which are the cases?
22, 24, and 25.
Yes, Your Lordship. It may get disposed of.
No, Your Lordship, notice was issued in the similar matter. This is where the girl's application was not uploaded online, Your Lordship. It is not the case of the school. The school's name appears, it's just that the girl's applications were not uploaded online, Your Lordship.
Okay, so notice was issued.
Yes, Your Lordship.
Okay, item 23, 24, and 25.
22, 24, and 25.
22, 24, and 24, and 5. Similar order. She'll give you a copy.
Yes, sir.
You send it to me with the file.
23. Good. But 23, perhaps it will cover the same order. Same order. So, my lordship can pass, my lord. Similar order, 23. Because interview
This
is
one?
No, this one, my lord. Interview is on 4th, my lord. That is the urgency, my lord.
This you keep in item number 22. Yeah, 22.
22,
Similar order.
that order, my lord. Similar order. Same.
You heard Miss M.K. Brown, learned counsel for the petitioner, and then Miss P. Das, learned standing counsel, secondary.
Yes, Your Lordship.
Education Department accepts notice on behalf of the respondents.
Extra copy is served.
That you take note, otherwise the order is safe. Okay, that order is there.
Take it out.
And this case?
23, my lord. That case, my lord. Same order. Same.
Last paragraph, Your Lordship has made an observation that their candidature should not be rejected on that ground of calendar and SOP. However, it will be made to subject to the outcome.
And his subject combination is same, my lord. Mathematics major, statistics and computer science major. And his interview is on 4th, my lord. 4th July.
Okay. Notice will go.
Notice will go.
Similar order.
Similar order.
Is also okay. Item number 23. All right.
High level.
Great level. High level.
I think that's complete, isn't it?